you whether or not there is any prejudice suffered by the defendant as a result of the late disclosure. I'm interested in those two issues.
Your Honor, there are actually three items of concern to the defense with respect to our requests for sanctions. At the close of court yesterday, it was off the record, but we noted the problem that arose with respect to Mr. Goldberg's examination of Dennis Fung, and we were able to locate the transcript reference on October 5th.
Your Honor, I'm sorry, but if there's going to be something involving Mr. Goldberg's questioning of the witness, may I have a moment to get Mr. Goldberg either down here or watching upstairs to make sure that nothing's misrepresented, since I wasn't here and I don't know what he's talking about.
Well, counsel, I can't wait to conduct these proceedings for the attorneys to shuffle back and forth.
Well, Your Honor, I don't know if there was any notice that Mr. Yeoman was going to argue anything with regard to sanctions.
Well, when we left yesterday afternoon, it was brought up that reference was made to items that the court had suppressed at the 1538.5. So clearly there's going to be some severe sanction.
All right, Your Honor, I think I actually may be more familiar than Mr. Goldberg with the suppression motions.
But I'm interested in talking about the tape sanctions first.
All right, I can address that issue first, Your Honor, and then address the question of the suppression and also the investigation with respect to the shoes. The videotape was first revealed on March 24th, I'm sorry, and of course this was a tape that was made on June 13th. There were a number of informal requests that were not on the record with respect to the production of this particular videotape, and at the time of the late production of the videotape recorded of Mr. Simpson bidding farewell to the Brown family, concerns were also again raised with respect to the existence of any other videotapes, and a specific request was made at that time, I believe on the record, for any other videotapes in the people's possession that had not been turned over. I think you need to put this in the context, Your Honor, of the importance that videotape evidence has assumed in this trial. We saw a very good example of that with respect to the prior incident involving the videotape of the night of the recital at the junior high school, where witnesses had testified that Mr. Simpson that evening was hostile and uncommunicative, and then we saw a videotape in which we could make our own judgment and in which he appeared to be very, very friendly and bidding an affectionate farewell to his children and to members of the Brown family. So this evidence has crucial significance in terms of allowing the jury and the court to make their own judgments without having descriptions of events filtered through the testimony of witnesses who may have biases one way or the other. And in light of the record of the prior failure to disclose a video, the failure of the prosecution to produce this particular videotape until March 24th takes on a special significance, especially the fact that it appeared at a point in time when it somehow seemed to the prosecution's advantage to use the tape. So the explanation that this was inadvertently mislaid is a somewhat suspicious one in view of the fact that suddenly it is relocated and brought into court at the point in time when they feel there is some evidentiary use that can be made to bolster their case. And of course, the defense was deprived of any opportunity to use this tape in prior issues that were being litigated before this court. And in a number of respects, we believe that that irretrievably prejudiced the defense. First of all, this tape would have been of substantial use in litigating the motion to suppress evidence back in September, and it would also have been quite useful in cross-examining the detectives in charge of this investigation, because we have noted inconsistencies between the description of the discovery of the glove, for example, in the closet of Mr. Simpson's bedroom, as portrayed in the tape, where a single glove was removed, brought downstairs, put on a table, and appears in the videotape. That is not the way that incident was described in the affidavit for a search warrant, which was subscribed to under oath by Detective Van Adder back on June 28th. At that point, Detective Van Adder said, and this was the probable cause, you'll recall, to go back to Mr. Simpson's home and execute a second search warrant 2 weeks after the execution of the first warrant. The probable cause included the allegation that additionally, since the service of the first warrant, other officers present during that service have told your affiant that they saw another pair of gloves inside Simpson's residence. These officers had also seen the glove found at the murder location and have told your affiant that the gloves in the residence appeared to be of the same type as the one from the crime scene. Your affiant wishes to seize the gloves left in the Simpson residence because they will tend to further establish that the bloody gloves recovered belonged to Simpson, in that he favored this type, style, and size of glove. These gloves were inadvertently left behind at the Simpson residence. Now, we believe that cross-examination, both of Detective Van Adder and the detectives involved in finding that glove, would have disclosed additional misrepresentations in the affidavit for the second warrant, in that the videotape reveals one glove, whereas the affidavit refers to a pair of gloves. The affidavit says the gloves were inadvertently left behind, when we have since been told that the detectives actually conferred with the detectives in charge and made a decision not to seize the glove. It was not an inadvertent leaving behind. They actually decided before they left the premises that they would not take this glove or these gloves, if there are two. So here we see significant areas for cross-examination that the defense was deprived of at the motion to suppress and in the cross-examination of the detectives, because we did not have this tape. We did not have the opportunity to see what this tape portrays. Now, clearly, there is a parallel, I think, between the failure to produce this tape and the failure to produce the tape involved in the cross-examination of Rosa Lopez. Because in both cases, Your Honor has been presented with a very similar explanation, that a detective inadvertently mislaid the tapes and that counsel were not aware that the tapes were in existence. And that's precisely the explanation we're hearing now from the prosecution. Despite that explanation, in the case of the Rosa Lopez tape, Your Honor concluded that severe sanctions were warranted. And those sanctions included fines imposed against both lawyers, a requirement of immediate corrective action to catalog all of the statements of witnesses and indicate when they were turned over to counsel, and a proposal to instruct the jury that the failure to produce this tape could be considered in assessing the credibility of the witness. We believe that if the court is going to be even-handed in the administration of sanctions, that precisely the same sanctions are warranted here, that Your Honor should order corrective action be immediately taken to require that the prosecution immediately catalog all videotapes in their possession or in the possession of the police with a description of those tapes and an account of when they were turned over to the defense. Secondly, we have proposed a jury instruction that closely parallels the instruction that Your Honor proposed to give with respect to the testimony of Rosa Lopez, informing the jury that the laws governing criminal procedure in California require disclosure of evidence in advance, that the reason these laws exist is to promote the ascertainment of truth, to save court time, and avoid the necessity for interruptions and postponements, that the delay in the production of this tape from June 13th until March 24th was a violation of the law and the cause of delays in this trial during the week of March 27th, and that the jury may consider the effect, if any, of this delay in disclosure upon the credibility of the witnesses involved in the gathering of evidence on June 13th. That would closely parallel what the court ordered in the case of the Rosa Lopez tape. The second issue that is of concern to the defense with respect to sanctions involves the very late production, again on March 24th, of 238 pages of investigative material relating to the prosecution's attempt to identify locations in which shoes matching the shoe print left at the crime scene were sold. This investigation took place in August and September of last year, and apparently the prosecution deliberately decided that they would not turn over any of this investigative material until their investigation had been completed. So all at once, on March 24th, the defense is handed 238 pages of material, much of which is in a foreign language. There is correspondence in that file in Japanese and Italian that we're going to have to get translated. We're going to have to conduct some follow-up investigation ourselves, and we believe, once again, we have an example of the prosecution simply withholding vital evidence until it's too late for the defense to do any investigation of their own. We believe that at a minimum, the court should delay the presentation of any evidence relating to the identification of footprints until the end of the trial, that the court should require immediate disclosure of any follow-up investigation. We need to know just as quickly as possible what the net results of all of this were, whether they are going to be presenting any evidence identifying the source of any shoes, and we need to know that right now so we can begin to prepare to cross-examine so that we
The results of the FBI testing on the shoe prints was turned over to you within a day of the court receiving it from the FBI.
What we're talking about here, Your Honor, is the effort to connect that particular shoe pattern with the sale of shoes at particular locations. I mean, this really relates to the effort of the prosecution to try to tie that shoe to Mr. Simpson. We are not aware of any evidence that in any way connects shoes of this nature with Mr. Simpson. And if they're going to put on any such evidence, engage in any attempt or inference to suggest that shoes of this type were purchased by Mr. Simpson, we need to know about that, and we need to be prepared to meet that evidence. As at this point, we have seen nothing, we have heard nothing, except this 238 pages of material that was turned over just 1 week ago. So we would ask at a minimum that the presentation of this evidence be delayed and we be given any follow-up investigation that came in its wake. The third item, Your Honor, relates to the direct examination of Mr. Fung at the close of our proceedings yesterday. And as I mentioned, we have located in the transcript the court's ruling on October 5th, 1995, pages 2395 to 2396 of the transcript. And here I'm reading from the statement of the court. All right, search warrant number 2, items 15 and 16, the ticket receipt and baggage tag. And I think Mr. Ullman was correct. I think the prosecution has the burden as to these two elements. Ms. Clark, that's correct, Your Honor. With respect to items 15 and 16, the prosecution will not be seeking to admit them. The court, all right, then we will take items 15 and 16 and note that they will not be offered. The representation is that they will not be offered. In the event that position should change, then the defense is entitled to a de novo hearing on the 1538 during trial if that becomes necessary. And yesterday, in violation of that agreement, Mr. Goldberg elicited from Mr. Fung testimony with respect to the seizure of both of these items, the airline ticket receipt and the baggage tag. We believe that this is a very egregious violation of counsel's duty to deliberately elicit testimony and evidence that the prosecution agreed would not be offered in frustration of the defendant's rights to seek suppression of that evidence. And we believe, once again, that severe sanctions are warranted, including the giving of an instruction to the jury. And we have fashioned a proposed instruction. We would propose that the court instruct the jury as follows. The laws governing criminal procedure in California require the exclusion of evidence that was unlawfully acquired by the police. These laws exist to protect the privacy of all citizens by deterring unlawful police conduct. Prior to the trial of this case, the prosecution represented that some items of evidence would not be offered in the trial, and the court withheld a ruling whether they were lawfully acquired. During the testimony of Mr. Fung, the prosecution violated their agreement, and you may consider the effect, if any, of this violation upon the credibility of Mr. Fung and give to it the weight to which you feel it is entitled. Your Honor will note that this instruction closely parallels the instruction that the court proposes to give with respect to Rosa Lopez. We also feel that a fine would be appropriate as a sanction in this case as well. Your Honor, in the moving papers with respect to sanctions, the defense has made a proposal to in effect call off this escalating war of sanctions, which is frequently characterized by hyperbole and over-dramatization and personal vituperation, and simply put over to the end of this trial, after all of the evidence is in, all of the issues with respect to what punitive sanctions are warranted in this case. While the court must, of course, immediately address questions about needs for delay in the presentation of evidence or arguments with respect to the total preclusion of evidence, we believe that preclusion is not a remedy that is going to be seriously considered with respect to any evidence in this case, that the court will more often be dealing with issues involving fines and retaliatory jury instructions. Of course, we're hopeful that the court will never have to deal with any of these issues again, but that hope certainly has not been warranted up until now. We believe there would be three very good advantages to the court in putting these issues over. First of all, it could expedite the presentation of the evidence to the jury, which is sequestered, and avoid the interruptions and distractions of arguments about sanctions that seem to be coming up with recurring frequency. But more important, it would allow the court to assess the issue of prejudice, the issue of willfulness, and most important, the issue of the extent to which jury instructions of this nature might undermine the reliability of the truth-finding process in the context of the entire trial, in the context of what the defense has done, what the prosecution has done, what pattern of willfulness emerges, and what degree of prejudice emerges in the context of the entire trial. I think it's interesting that in the few appellate cases considering sanctions pursuant to California's reciprocal discovery law, there have been some reversals of the imposition of sanctions, but the appellate court has the virtue or the advantage of looking at the effect of the sanctions in the context of the entire trial and how those sanctions affected the fact-finding process that was ultimately handed to the jury. There is no reason on earth why a trial court should not have the same advantage and should not be able to look at this whole question of sanctions in the context of what impact it had throughout the trial before the final instructions are given to the jury. And if Your Honor feels that instructions are necessary, those instructions can then be incorporated into the final instructions to the jury. We believe that the third advantage this would give the court is even-handedness, that Your Honor would be able to assess the relative culpability of the defense and the prosecution at the same time and balance the scale of what sanctions are appropriate with respect to each side. In that respect, then, we would request that Your Honor withdraw the order that you entered on March 1st with respect to sanctions relating to the Rosa Lopez tape and simply put over this question of sanctions to the end of the trial and address all questions of punitive sanctions and retaliatory instructions at that time. But if Your Honor is not so disposed and feels that each sanction issue should be addressed as it occurs, we would alternatively request the instructions that we have asked for with respect to the June 13th videotape, with respect to the elicitation of evidence that the prosecution agreed would not be offered and should impose fines as sanctions.
Thank you. Ms. Lewis.
Your Honor, good morning.
Morning.
Your Honor, I believe this area of discovery violations and sanctions needs a reality check, and that reality check has to be based on the discovery laws, because as those discovery laws point out, the only orders requiring discovery that shall be made in criminal cases are as provided in this chapter. Now, the provision of the Penal Code 1054.1 requires the prosecuting attorney to disclose to the defense a variety of materials, but the preface to the disclosure of these materials is that they must be disclosed if it is in the possession of the prosecuting attorney or if the prosecuting attorney knows it to be in the possession of the investigating agencies. The defense has failed to even make that threshold showing, which is required before any of these other issues, whether that's material, whether it's Brady or so forth, even becomes of issue. They have failed to make that threshold showing. It's uncontroverted that we did not know about this tape until March 24th. It's uncontroverted. We did not have this tape in our possession.
This was the problem, though, is that throughout this litigation, it has been brought up that the defense says, we know there's another videotape because we have information from the news photographers that there was some police photographer videotaping. Where's the videotape?
Your
And
Honor,
the representation was made that it didn't exist. That's the factual basis.
well, the basis is we made inquiry. I was personally present when inquiry was made of the lead detectives in the case, and they were unaware of its existence. Excuse me. and therefore told us that nothing existed. And it's clear why they were unaware of its existence, because all of the evidence elicited yesterday supports that this was a tape made solely for administrative civil liability purposes. The tape is, not only did Detective Harper, Detective Looper, the videographer, and Mr. Atkins' supervisor all testify that that was their understanding of the purpose of this tape, but the tape is self-authenticating in that regard. It does not show the pathway where the glove was recovered from. It does not show the blood drops on the driveway. It focuses extensively, I counted about 4 to 5 minutes, on all the trophies and the valuables within the trophy room. It shows the furniture within the residence. It shows the cars within the grounds of the residence. It shows all of these items of value, and it even shows the only damage or apparent damage, which was these 2 blood drops on the light wood floor, also for civil liability purposes.
But doesn't that contradict the testimony regarding when those blood drops were collected?
I don't know why Your Honor feels it does. I don't see any contradiction in that, Your Honor. There's no item numbers shown next to those blood drops, so presumably they were collected prior to this videotape being shot. I don't see a contradiction.
Well, if they're still there, how are they collected?
Well, I imagine it's a stain, blood stains. I don't think it could be completely removed from that light-colored wood floor.
Well, I assume those light-colored wood floors have a sealer on them.
Well, I don't think we can assume things like that, Your Honor.
Well, I stood on the floor.
Well,
Counsel.
I did as well, and I frankly don't recall whether it seemed to have a sealer or not, but I think that's a big leap to make, to say that because a tiny portion of this 25-minute video shows what turns out to be criminal evidence or evidence relating to the criminal investigation in the case, therefore this video becomes material in any constitutional sense or in any sense at all in terms of defense discovery.
Well, the problem I have, though, Ms. Lewis, is this. The request was made several times by defense counsel that they knew or had reason to believe that this tape existed. And they asked several times for it. And we got representations back several times. It doesn't exist.
Your Honor,
Now we find it exists.
it was our belief that it did not exist, and it is understandable how that happened, since it was made for this purely administrative purpose and was placed by Detective Looper, who's not been part of the discovery process, is not one of the lead detectives in the case, was placed by him in a file cabinet because and he only thought of it when it became known to him that he was going to be testifying in the case. So that's when he thought of it. That's when it occurred to him to look for aids that might be useful in refreshing his recollection during his testimony. He thought of it. He brought it to the attention of the lead detectives. They immediately told us. We immediately had it copied as soon as our lab was available. It was a Friday, I believe, that we discovered it, and we turned it over the following Monday. It may be unfortunate that this tape was not depicted sooner, but there's an additional point to be made. When you talk about defense prejudice, even assuming it was discoverable, and it was not, Your Honor, and I don't care if they made specific requests, if we had not planned, now that we know about this tape, we would like to use parts of it. We would have liked to have had it months ago and used parts of it in various other hearings. But even at this point in time, if we did not intend to use that tape at trial, it would not be discoverable. I don't care if they personally requested it or made a specific request for it. This is not Brady material. And in fact, under Brady, there need not be a specific request made. So that when we're talking about sanctions, Your Honor, and we're talking about imposing sanctions on the prosecution, that is a serious allegation and a serious matter. And it was serious for the defense, it's serious for us, but we're in a different context than the defense was in the Rosa Lopez matter. I'm going to talk about that in a moment. We're in a situation where we had no obligation to provide this discovery. If we had known about it, we would have. Of course, it would have been useful in examining the witnesses. It would have been useful during direct examination, not just cross-examination by the defense. We would have liked to have had this video, but we did not. And the fact that we do have discovered it now is simply to everyone's benefit. It doesn't mean that there was any prejudice inured to the defense. They failed to show any prejudice whatsoever in not having it. And along those lines, the photographs that the defense has had in their possession for months are actually much better evidence, as Detective Looper, I believe it was, alluded to when he testified yesterday, because the photographs show this evidence when it was recovered, after it was recovered. It shows all of these blood drops. It shows everything in better detail, because those photographs were taken indeed for criminal investigation purposes under perhaps under subdivision C of Penal Code Section 1054.1. Those are real evidence intended and shot for the purpose of criminal investigation purposes. So those photographs were discoverable. They were turned over. They're certainly the best recordation, much better than this video, of all of the crime scene evidence and the locations where items were recovered. The photographs show the pathway, the glove, and so forth. They show the criminal aspects of this case. They don't show all the valuable Heisman Trophy and all the other valuable trophies that the defendant had, because those were not part of the criminal investigation in this case, and there was no reason for those still photographs to depict them. The only thing that is shown on the videotape, which is not shown in these crime scene photos, that might have had some significance, was the linen closet, which was fingerprint dusted. But as Detective Looper testified yesterday, no fingerprints were recovered. There was nothing of evidentiary significance about the linen closet, and I don't believe the court has heard any testimony. I don't recall in the months I've been involved in this case any testimony having to do with the linen closet, because there's been nothing relevant about it. So there is nothing on this videotape that is not better depicted, much better depicted within the photographs the defense has had for months. Now, Your Honor, the Rosa Lopez situation is entirely different. The defense, under Penal Code Section 1054.3, Subdivision A, requires, the law I should say, requires the defense to turn over the statements of witnesses they intend to call at trial, recorded statements, recorded in any manner. The Rosa Lopez was on the defense September 1st, 1994 witness list. So their intention to call her at trial was clear and present for months before that tape was discovered. Now we have the defense would like to draw us into this, and it's the same situation as they're in, but we're not. The discovery statute, when it talks about if it's in the possession of the prosecuting attorney, or if the prosecuting attorney knows it to be in the possession of the investigating agencies under 1054.1, which is the statute that covers our obligation, makes that critical distinction between us and the police.
Do you think the 1054.1, that a reasonable interpretation creates an obligation for the prosecution to make reasonable inquiry and diligent search for these items?
We did, Your Honor. We did. We wanted...
No, I'm not asking you whether or not you did.
Well,
do you agree that a reasonable interpretation of that code section
yes,
requires inquiry to be made?
Yes. I think that is a reasonable interpretation of that code section. But unlike that section, the defense, the section governing the defense obligations, discovery obligations, makes no distinction between the defense attorneys and the defense investigators. And that's clear why. The police department is a separate agency, a separate entity. It's not even a county department. It's a city department. We're in total different forms of government or totally different bureaucracies. We don't pay the police. We don't order the police around. The police aren't beholden to the DA's office. We don't pay their salaries. They have similar goals that we do in terms of some criminal prosecutions, so of course we work in conjunction. But it's a different situation when you look at the defense side of the table. Their defense investigators are employed directly by them. They do take orders directly from them, and that distinction is recognized in the discovery statutes by the failure of the statute governing defense discovery to make any distinction between the defense attorneys and their investigators. So when it came to the Rosa Lopez tape, the defense attorneys were charged with the knowledge of that tape that Mr. Pavlik had in his possession. Not so with us, and that's not so because of the express terms of the statute. So we're talking about apples and oranges. In addition, of course, the defense, when it comes to the civil liability aspect of this particular videotape, the DA's office wouldn't be sued if the police had seemed to have done something to cause damage to those premises. The Los Angeles Police Department would be sued, and they have been sued. And they do have the choice now, the detectives have the choice of recording either by videotape or by still photos locations where search warrants are executed to make sure that they've got a record of that in case of a later suit. I'm sure the court's aware the department's sued all the time. So they have different administrative liabilities and problems than does the DA's office. I guess we get our own lawsuits in some respects, but certainly nothing to do with the execution of search warrants. And, Your Honor, the defense keeps talking about this recital tape. We're not talking about the recital tape anymore. The court made inquiry about that, of the June 12th recital that the defendant attended. The court made inquiry. We didn't know we had it. Apparently, I don't remember exactly how that came about because I wasn't personally involved with that. But when we found it, we turned it over. It certainly was not material evidence. And, and the court has to consider that this, as I said, even...
Ms. Lewis, how can you say that it's not material evidence where the prosecution's theory is that there was this tension and anger expressed by the defendant on the date in question at the dance recital, and that he was glowering at people and was in another emotional state of mind, and yet we see him greeting the Brown, or saying goodbye to the Brown family and smiling and greeting his children? I mean, that's directly contradictory to the testimony of the prosecution witness. So how can you say that that wasn't material?
No, to the contrary, Your Honor, it directly supports the entire prosecution theory. When Mr. Simpson was inside that auditorium, when he wasn't in the public domain where people would be looking at him, he's thinking about other things, that's when the witnesses testified as to those expressions. When he got outside, was aware, greeting people, and was aware, that became his public persona. And as Mr. Darden told the jury during opening statement, this man has two personas. He has the public face and he has the private face.
All right, let's move on to the FBI shoe print matters.
The defense, Your Honor, has still failed to show how these materials fall under the discovery laws. As I indicated to the court the other day when this whole issue first came up, these materials are basically correspondence. They're materials sent out by the FBI to manufacturers in an effort to investigate this whole shoe area.
Do you plan on calling Bill Boats yet?
Yes.
Aren't these his work material and his reports and his efforts to investigate?
Well, these are investigative efforts. I would call them investigative efforts. And they have now been turned over. But, the investigation is ongoing. We may not have seen the end of the shoe evidence. It is ongoing today as we speak. There are people investigating this area. And, I don't want to fill the court in on the details, but...
Well, the problem I have, though, is that these reports go back to August of 1994. These letters and this correspondence...
Your Honor, these are not reports. Let's make that clear. These are not the reports of experts, and they're not even the experts' notes. It's correspondence as part of the investigation. I'd invite the court to take a look at what we're talking about, because this material clearly does not fall under the discovery laws. We've chosen to make it available, give it to the defense, but even the cover letter from the FBI indicates that they've reviewed all the discovery requests directed to the FBI and unless otherwise noted, have complied with each of them, even though many are clearly outside the normal scope of discovery. That's the letter from Mr. Shapiro, the general counsel for the FBI. So he's saying that we're going to give you everything, even though it is outside the normal course of discovery. And, as Mr. Goldberg actually pointed out the other day, because we've been so generous in this case and have, well, I'm not sure he pointed this out, I won't lay it on him, but I'll make the point, that because we have been so generous in this case and going through hoops and providing the defense with an incredible amount of discovery, way beyond what we were ever required under the law to do, they're turning around and trying to slap us in the face with it. We've given them too much. This stuff is not even discoverable. If we'd not given it to them, they would have not known about it. Here they have it weeks in advance of any evidence coming on with regard to the shoes. They have it when they don't even have to get it, and we gave it to them as an extra courtesy. But, let's go back, Your Honor, as we've made the point in previous motions, we did provide, I think it's over 23,000 or maybe more by now, pages of discovery, hundreds of videotapes, audio tapes, etc.
Let me ask you this, Ms. Lewis. I only was provided with a few what were deemed by the defense to be representative pieces of that 238 pages of material regarding the shoes from the FBI, which seemed to indicate a search to identify that particular sole pattern, is my recollection of what I read. Have you identified, to your knowledge, that shoe pattern?
We've identified the shoe pattern, yes, as being that of a Bruno Magli shoe, Bruno Magli. Indeed, Your Honor, the defense was provided with the reports and the final discovery and what is discoverable. These, when it comes to experts, not the whole world's discoverable. As the court knows, the court did a lengthy in-camera. I'm assuming that we prosecutors did not get every bit of information. I'm sure the court made a careful evaluation in determining what was discoverable and what was not. And in this case, it was obvious to us clearly that this is material which is not readily discoverable. It's not provided, and we did provide the bottom line reports with regard to those shoe prints.
What I was getting at is Ms. Lewis, is what is the materiality of the items that were turned over? What is there?
There is no materiality of the items that were turned over. I'd be happy to lodge. This happens to be our only copy, but we can make a copy, or I'd lodge our
All right,
originals.
would you have your staff make a photocopy of that and lodge it with the court so I can read it?
I'd be happy to do that, and we'll do that, Your Honor.
All right, would you address the testimony of Mr. Fung regarding items that were withdrawn by the prosecution?
I will, Your Honor. I had one final point I wanted to make. I wanted the court to be aware that its favorite language in the Augers case was not overruled by the Bagley case, as the defense, Mr. Thompson, Mr. Thompson, the defense attorney, made the representation the other day. The Bagley case reaffirms Augers and talks about when something is considered constitutionally material. But even in the Bagley case, it was undisputed that the material was Brady material that was at issue in that case. There were contracts with prosecution witnesses, and as far as what payment they would receive, depending on how much information they gave. So that was clearly and obviously Brady material. But there has to be a showing of constitutional materiality, Your Honor, for something to be discoverable under Brady, and there's nothing even come close to that in this videotape. And I'll reiterate the point that the stills photographs show better everything that the video show better, because it shows not only during the early time, but
Counsel,
later
you've made that point already.
I realize that, Your Honor. All right, with the court's permission, since I wasn't present yesterday, and I know what the issue is, but Mr. Goldberg would like to address the court with regard to Mr. Fung's testimony.
Morning, Your Honor.
Morning, Mr. Goldberg.
Just to clarify the record, I think to my recollection it was Mr. Scheck that made the comment about Augers being recalled. I nodded at the inappropriate time while Ms. Lewis was looking to me for affirmation. I think it was he and not Mr. Thompson, so I did not want to have the court misled in that regard. Not that it's that particularly important. On the issue of the testimony by Mr. Fung, this is a situation, Your Honor, where the prosecution immediately upon realizing, specifically me upon realizing, that question should not have been asked because it was eliciting information that had been suppressed, instantly agreed with the defense that it should not have been asked, it should not have been elicited, and Ms. Clark agreed. So this did not require any argument. It did not require looking at the transcript. And I just don't understand why Dean Ullman would feel that it is necessary to go back and argue from a legal perspective something that we had immediately conceded, unless he's interested in simply the public excoriation of the prosecution, or in this case, of me. I just don't understand the necessity of that. I would agree with the Dean that there has been an escalation in terms of requests for sanctions, perhaps because the defense, in our view, was legitimately sanctioned for some very serious discovery violations in instances where there was at least circumstantial evidence, strong circumstantial evidence, I believe in the court's opinion, that there was either intentional or negligent misrepresentations that were made before this court regarding issues that went right to the credibility of
Well,
material
let's
witnesses.
put those other issues aside as being apricots and oranges at this point.
Well,
My interest here is, given the agreement of the prosecution to withdraw those items, how did this happen?
Well, Your Honor, the way that it happened is very simple. I was not here when that happened. As the court knows, I was a relatively speaking recent addition to the prosecution in this case. There are a large number of issues that were litigated, and I did not know about that. It was not communicated to me. It was an error. It was a mistake. We made a mistake.
Doesn't the prosecution have some obligation within the team members to communicate with each other and organize the presentation of this case?
Of course, Your Honor, and we have done that. But does the court honestly believe, I'd ask this question rhetorically, that I am going to ask Ms. Clark, were the airline tickets suppressed? I mean, of course I have been communicating with her about my presentation of the case and all the tactical issues and how we're going to present it. I think that Your Honor recognizes that. But no, I did not ask her whether the airline tickets were suppressed. And if I should have, and I failed to, then I made a mistake. But I did not ask that question. Sorry, they were not suppressed. They were litigated, as Ms. Lewis just pointed out. What I would say on this issue is my sole reason for asking that question was not because I thought there was anything relevant or material per se about them, but I simply wanted to get the sequence of events, particularly as it related to Detective Van Adder giving the blood vial to Mr. Fung. I wanted to be very careful in terms of our presentation of that part of the evidence and what sequence of events occurred and what pieces of evidence he collected just before he left and received that vial. The airline tickets themselves, it would seem to me, based upon what the jury has heard of this, if anything, would be something that would be somewhat favorable to the defense in the sense that it would seem to indicate that the trip was a planned one as opposed to being unplanned. So it certainly doesn't have any evidentiary value in terms of the content of the evidence as opposed to the timing sequence as far as the people are concerned. And from a legal perspective, when the issue of an instruction to the jury is raised, what I would point out to this court is that it is a well-recognized principle of law that unless an objection is lodged, the objection is waived. And there was no objection by counsel. I don't know. They haven't even represented to the court in good faith that they didn't intend to introduce the evidence themselves of the airline tickets. So they didn't object to it. They didn't do anything until they discussed it at sidebar with Your Honor and with Ms. Clark and myself.
At the end of the day.
At the end of the day. But they didn't object at the time when an objection could have been sustained to the question and at a time when any evidence could have been precluded. So legally speaking, I think that we would be entitled to take the position from a legal standpoint that there's nothing more for the court to do. That's not the position I'm taking. If the court wants to admonish, if the defense wants this, that question and that answer is struck, we would concede that is an appropriate way of handling it. Legally, it may not be necessary, but we would concede that is an appropriate thing for the court to do. But to give an instruction of the kind that Ullman is proposing doesn't make any sense. And the only reason that I compared this alleged violation to certain of the other violations that Mr. Ullman discussed is because he drew a comparison, and he was analogizing to the instruction that the court was proposing to give for the Rosa Lopez incident. And they are not analogous, because what happened in the Rosa Lopez incident is that the prosecution was deprived of, until the last minute, materials that were very significant in terms of the cross-examination and the credibility of that witness. There's been no analogous violation by the prosecution with respect to Mr. Fung. What has happened with Mr. Fung is I asked him a question that he had absolutely no way of knowing was improper, and he answered it as he's required to do as a witness. It in no way reflects upon his credibility. It in no way reflects or diminishes the capacity of the defense attorneys to cross-examine Mr. Fung effectively, or deprives them of materials to make the cross-examination effective, or deprives them of the opportunity to have a sufficient period of time to examine those materials. So you're not dealing with any of the problems that you are in the case of Rosa Lopez, where discovery was held back on some very important statements that she made that we used for the purposes of impeachment. I don't know whether the court wants me to address the issue of fines. I will if the court wants to hear about that.
Well, it's something that might happen, so this is your chance to say something.
Okay. As to the issue of fines, first of all, in the criminal context, there is no statutory authority for the imposition of crimes to the same extent that there is in the civil context. It's been a while since I've practiced any civil law, but the Code of Civil Procedure does provide for the imposition of fines for a wide variety of things in addition to discovery violations. I believe that a court in a civil hearing can fine counsel for making frivolous motions. Perhaps some viewers of this case wish that the court had the authority to do that here. But there is case law to indicate that the Code of Civil Procedure sections dealing with fines do not apply in the context of a criminal case. What we do have now in the post-Proposition 115 context is a specific provision in 1054 for fines for discovery violations, but that's it. So legally, there is no basis for fines outside of that area, unless the court were to hold the prosecution or me in contempt and then to fine me that way. But other than that, there's no authority for the imposition of a fine.
Don't you think I have authority under CCP 177.5, the court having ordered that before any new mention was made by the prosecution, that notice was to be given to the defense, and that they were then entitled to a de novo 1538.5?
No, that's what I'm saying is I don't believe that the Code of Civil Procedure sections apply in a criminal context with respect to
Right, well,
fines.
the case law is pretty clear that I have authority under 177.5 to impose fines.
I'd have to look that up then, Your Honor, because I thought I read a case several years back that said that the court did not. But I may be mistaken about that, so I don't want to represent something based upon my recollections of a case that I read a very long time ago.
All right, well, just so you understand, it's my position that I have the ability to impose sanctions up to $1,500.
Okay.
And I feel comfortable with that.
Okay. If the court were inclined to do so, I'd like an opportunity to go back and find that case, because I do have it in my computer. Unfortunately, it's at home. And I did not know that counsel was going to be asking for fines, because when we had our little discussion, it seemed like Mr. Cochran and I think maybe Mr. Shapiro was there, felt that this was not a major deal and that a lot more is being made of it than was yesterday evening. The other thing I'd say on the issue of fines, it has to do more with a practice in our legal community than with the actual law, and that is that I'd like to point out that the prosecution did not request fines of the defense attorneys in this case as a result of the discovery violations. And there are a number of reasons that we didn't do so, and I'm not in any way criticizing the imposition of fines by this court. But it is our feeling that it is not appropriate in that kind of a situation for an advocate to ask for fines against another advocate, even for something that amounts to an intentional or reckless misrepresentation, and that was our reason for not doing so. I'm not in any way commenting upon the imposition of fines by Your Honor. We're just saying what our position was and why we didn't ask for that. I believe, based upon my practice, that there is an unwritten rule that fines are generally not imposed and generally not requested by criminal practitioners in our local legal community.
But it's a sanction that the court has available to it to maintain order in the court and to maintain respect for the orders that the court makes. So it's a sanction that the court uses, not necessarily at the request of the parties.
Well, I was just explaining to Your Honor why we did not request it, and I'm also explaining why we are somewhat surprised by the fact that Dean Ullman has requested this, and somewhat surprised by the fact that the defense has requested it in general.
Well, they didn't like the fines that they got. That's the basis for that, I understand.
But I'm just saying that we did not ask for them. I was pointing that out. Yes, Your Honor is right. You do have the capacity to maintain order But what I would suggest on that issue is, how is it going to maintain order of this court by imposing a fine? How is it going to deter any future violation of something that we are entirely unaware of and that a reasonable person would not have made inquiry into? You know, yes, I did discuss my aspects of the case with Ms. Clark, but as I said, Your Honor, I did not ask specifically whether the airline tickets had been suppressed. And if the court is concerned about deterring future incidences of this kind, I don't see how the court can deter that kind of unintentional mistake. It is not the first mistake that has been made in this case. It won't be the last. There are going to be other issues that come up by both sides. I think we know that, and that is a fair statement based upon what has happened here heretofore. So I'd ask the court to consider all those issues, but more importantly on the issue of an instruction, because that would adversely impact the interests of our client, the people, and adversely impact the credibility of this witness if the court were to give any instruction of the kind that Mr. Ullman has proposed. That is simply entirely unfound from a legal perspective, from a common sense perspective. It in no way relates to this witness's credibility. That information that was agreed not to be elicited was put before the court. And we would ask the court simply to tell the jury that the question and the answer to the question are stricken.
All right, Dean Ullman, 10 minutes.
Listening to the response of counsel was somewhat of a deja vu experience. We were hearing lots of echoes of the argument that preceded the court's imposition of sanctions against the defense. The I wasn't there defense. I recall that Mr. Cochran's declaration to the court indicated that he came into the case later, that he did not direct the activity of Mr. Pavlik as his explanation of why he wasn't aware that the tape existed with respect to Rosa Lopez, that we didn't know it existed defense.
Well, let's not relitigate that issue.
All right. Well, there's one thing that wasn't echoed, Your Honor, and that was any expression of contrition. No apology. In fact, defiance. In fact, the suggestion being made that we've been overly generous in what we've turned over to the defense. Your Honor, there's an attitude problem here. And frankly, the response of the prosecution, I think, should create greater alarm for the court. It certainly creates greater alarm for us than existed prior to hearing what they had to say. I mean, the suggestion that whatever the police have in their file cabinets, we have no responsibility to inquire into except to ask them if they have it, that this is not Brady material, that evidence of the significance of the videotape of Mr. Simpson's demeanor on the day that the murder took place, 3 hours before the murder took place, that's not Brady material. That this tape shown the very day after of the condition of the premises and showing the blood spots, and the suggestion that this was just an administrative videotape just doesn't wash. If there was any concern that the people or the police or the prosecution might have had that there would be some liability for the premises, the condition in which they left Mr. Simpson's premises, you would have we would have had a videotape showing the plumbing job in which they actually removed the drain pipes from some of the plumbing, from the sink in Mr. Simpson's bedroom. That's not even on the tape. What is on the tape is a portrayal of gloves, a portrayal of blood spots, items that are of great evidentiary significance in this case. And I think what we see is an attitude that just doesn't recognize that there is an obligation to make this kind of evidence available to the defense. And we would seriously suggest that perhaps Your Honor needs to order that the prosecution have a look at what's in the file cabinets. I mean, the suggestion that police can just put things in the file cabinets and we don't need to worry about what's there, frankly, we're worried. We're more worried now than we were before. If these two items that have shown up tardily are an example of what else may exist in police files, we think Your Honor should order the prosecution to make a complete examination of all of the evidentiary items and reports in the possession of the police department, and that Your Honor, if there is any question at all, should yourself examine this material and apply a true standard of what Brady requires. Apparently the prosecution just doesn't have any conception of what their Brady obligations are. Now, with respect to the specific items here, the videotape, first of all, Your Honor is correct that the specific inquiry was made as to the existence of that tape. So what we have here is conduct bordering on willfulness, certainly conduct showing recklessness, and certainly no greater showing of willfulness than existed with respect to the Rosa Lopez tape.
Are you seeking the suppression of the tape?
No, we are not. We are not asking for preclusion with respect to this tape. We believe there is evidence in this tape that is favorable to the defense that we may want to use. The prejudice we're asserting, though, is that we got it so late that we couldn't use it in our motion to suppress. We couldn't use it in cross-examining the detectives in charge of the investigation, and counsel didn't even address the question of the inconsistencies between what this tape suggests and what the search warrant affidavit suggested. So we believe we have made an ample showing of prejudice with respect to the failure to produce this tape at an earlier point. With respect to the investigation of the shoes, the explanation that an investigation is ongoing does nothing. In fact, it suggests, once again, that the prosecution interprets their obligation as simply doing their investigation, and then when they're done, turning over the results of their investigation.
No, 1054.7 provides the means to shield confidential matters if it's necessary to do so to complete an investigation. That argument doesn't fly.
Okay,
So don't waste
and
your
they
time
should
with
have come to you and
Don't waste your
sought
time
that.
with it.
All right. With respect to the relevance of that material, for us to do follow-up investigation, there's a lengthy chain of distribution that the prosecution is attempting to track down, showing what manufacturers were allowed to use this pattern, which of those manufacturers exported to the United States, where in the United States shoes that have this pattern were on sale. There's a lengthy chain of distribution that we are going to have to retrace if, in fact, they are going to offer evidence to suggest somehow that these shoes were available for sale in the United States in a place where the defendant might have acquired them.
Do these 238 pages deal with that?
They do. They do indeed. They are inquiries to specific manufacturers, to specific distributors in an attempt to track down where these shoes were distributed and sold. And finally, with respect to the issue on the suppression, I think it goes without saying that any counsel who comes into the case is going to have to familiarize himself or herself with the prior rulings of the case. I mean, if the defense or the prosecution can just bring in a new lawyer and ignore prior agreements and rulings of the court, and then when called to account say, well, I wasn't here when that happened, there's no way that this court can conduct a reasonable trial. The objection was made immediately after the close of court yesterday, and as I recall, These were the last questions addressed to Mr. Fung at the end of his testimony yesterday. So certainly, I don't think we can suggest that the defense waived this issue by not making a prompt objection. We believe that simply striking the question and the answer does not communicate the degree of egregious misconduct by counsel involved in asking and answering these questions. Now, Mr. Goldberg says, well, an instruction doesn't make any sense. To tell the jury that they should consider this with respect to the credibility of Mr. Fung makes no sense because it has nothing to do with the credibility of Mr. Fung. That overlooks the nature of the jury instruction as a punitive measure. The failure to promptly disclose the tape involving Rosa Lopez didn't have anything to do with her credibility either.
Yes, it does.
It does not, Your Honor.
Yes, it does.
Well, I respectfully suggest that the tape was produced, they did have it, and they were allowed to use it for cross-examination.
Which
The
is precisely why it goes to her credibility.
The tape goes to her credibility.
Absolutely.
Right. But does the delay of the defense in disclosing the tape go to her credibility?
And that's for the jury to decide.
That is for the jury to decide as a punitive measure, to punish the defense for not producing the tape. And by the same token, we would say it's for the jury to decide what credibility they should give Mr. Fung's testimony when the prosecution deliberately elicits evidence and testimony that the pretrial agreements provided were not to be elicited.
All right, counsel, wind it up, please.
All right. With respect to the fines, again, we're simply asking that the court be even-handed and address the question of sanctions from the same perspective that you addressed them with respect to the defense counsel. In fact, we have suggested much more modest fines because we do not want to deprive the prosecutors of the means to come to court suitably attired. But I can certainly loan them some sackcloth. I think they'd look good in it at this point, certainly better than I would look in a dress. To conclude, Your Honor, I think, frankly, the best way to handle this whole situation is simply withdraw the order of March 1st and put over to the end of the trial all issues of punitive sanctions, so Your Honor has the benefit of a full record of the conduct of counsel throughout the trial at the time you address these issues.
Thank you, counsel.
Your Honor, just for the record, there was no plumbing torn up or taken or done anything else with on the 13th.
All right, court will make the following order immediately. The district attorney's office is ordered to prepare and submit to the court by the close of business April 7 an inventory of all video tapes that are in existence either in the possession of the district attorney's office, the Los Angeles Police Department, or any other agency that is involved in the investigation of this case. The district attorney's office is ordered to prepare and submit to the court by the close of business Friday an inventory of all reports, letters, and other items regarding the shoe evidence. Court will take under submission the request for sanctions, monetary sanctions, as to all three of these items. And Mr. Ullman, will you submit to the court the draft language of your instruction regarding the ticket and baggage receipt?
Your Honor, videotapes, could the order be a little bit more specific, because there is news footage, I think, that, I mean, our
Videotapes.
Media Relations Department has taped this case for days and days and days, so
Inventory of all videotapes. All. Friday, noon.
Including all the news shows we've taped for the last several months? I don't mean to be impertinent, it just is a...
All videotapes. Each and every one. This is the second time the prosecution has popped up late with a videotape.
This one was not in my possession, I've already made that point.
But we knew it existed and inquiry was made several times.
Well, we didn't, as I told you, we did not know it existed.
Well,
Detective Looper did, but we didn't.
Detective Looper's part of the prosecution team, I take it.
Not under the penal code section covering our discovery obligations, Your Honor.
I agree. I think the prosecution's very fortunate that that statute was written by prosecutors.
By the voters of the state, Your Honor, that was initiative that the
Oh, I
voters
agree, and
approved of.
that's the disability that the defense has, because the defense obligations are spelled out much more clearly than the prosecutor's obligations are. It's an interesting statute. All right, we'll take a 10-minute court reporter recess, then we need to take up the presumptive test issue. I'd like to see counsel in chambers for the 10-minute recess. I want to know what your position is on the presumptive blood test. All right, back on the record in the Simpson matter, the defendants again present before the court with counsel. People are represented. We have one more matter we need to resolve before we invite the jury to join us. That is as to the prosecution's offer of presumptive blood tests. Mr. Goldberg.
Oh, I see, it's coming right.
Your Honor?
Ms. Lewis.
Our media relations director asked for me to have the court acknowledge what to me is obvious. That is the tape that the inventory of tapes the court wants would be from June 12th, and of course only tapes relating in some manner at all to this case.
That's correct.
Thank you.
Your Honor, I had an additional citation that I wanted the court to look to, and it's Professor Mwimpere's treatise on scientific evidence, and specifically page 532, which discusses admissibility of preliminary blood testing and discusses the phenolphthalein test, and also cites Coleman, which I previously cited to the court. And the reason that I'm bringing this to the court's attention is because I believe that his interpretation of Coleman is the same as the interpretation that I offered to the court when I first cited it. And I'll also give a copy to counsel. May I approach?
You may. Thank you.
Your Honor, may I make one comment before you sign?
All right, who wishes to be heard first?
Just very, very briefly,
Could I beg the court's indulgence to make one more brief comment on the other matter? The drain at the defendant's residence was, the trap was removed on the 13th, and that was the extent of the plumbing, whatever that was done. I just clarified that with Mr. Funk himself.
I heard it was more extensive than that.
Your Honor, not for the purpose of argument, just to clarify what is the issue here, and that is that the people wish to introduce evidence of a presumptive positive in a phenolphthalein test. So we're dealing here right now with the phenolphthalein test, and we're dealing with their request to introduce evidence of the positive result. One of the things that I pointed out, Your Honor, is that a negative result is of a completely different nature. It is a conclusive test. It means that there couldn't possibly be blood there. So to lump the admissibility of negative results with positive results for the phenolphthalein test really raises a completely different issue.
What negative results do we have?
They did presumptive testing on stains all over the place. For instance, they saw reddish stains along the south wall of the house. Police did.
What negative results do we have?
Those were negative.
All right.
Those were negative. There's allegations of certain stains found in other places in the house as well, at Mr. Simpson's house. They tested those. Those were negative.
All right. What's the nature of the plumbing? You indicated that false positives come from copper plumbing. What's the nature of the plumbing at the Simpson residence?
I don't know. I can't answer that question right now. I have not examined the plumbing. But the main problem, frankly, with false positives for a phenolphthalein test, Your Honor, isn't even the copper. It's microorganisms and bacteria. And that's why I've called out to leading forensic scientists around the country, and they don't even use the phenolphthalein test for anything involving plumbing fixtures. They would take the residue or whatever it is that they want to test back to the laboratory and do confirmatory testing, which could assess what the item is. That wasn't even done here. Unlike the other items that they wish to introduce, there was some corroborative or confirmatory testing done. But as the Blake article points out, microorganisms and bacteria, which live in wet, moist places, such as drains, render the usefulness of a pheno test under those circumstances to be absolutely useless. So that's what gives rise to the 352 issue as well, Your Honor. That's why we're not opposing, for instance, the pheno result and the photograph depicting it of the stain on the floor of the bathroom.
Because that stain was collected and then tested, correct? All right. Mr. Goldberg?
What I'm hearing from the defense is somewhat troubling. What they say is, well, we can put in evidence of the negatives because, as the court will recall from Mr. Cochran's opening statement, he made a big point about blood not being located in certain places. So they want to create this inference buttressed now by scientific testimony that they're graciously not objecting to as to negatives in a variety of places, without also showing evidence of positives in other logical places that one might expect to find blood if a defendant who had just committed murders had come back to his residence, had gone upstairs and stripped off his clothes and taken a shower. That is the height of giving the jury a completely skewed and erroneous view of the evidence. This is a legal question for the court to decide, and it's a very simple legal question, and that is the admissibility of presumptive tests. But before I address the law once more on that issue, which we believe is clear in the state of California, I just asked the court to view it also from a common sense perspective, because we know that a person can come into court, a lay person, and testify that something appeared to be blood or even was blood, that's an appropriate lay opinion. We can ask Mr. Fung, who has some expertise, whether something appeared to be blood, and that kind of an opinion is far less reliable, obviously, than a forensic test. We also know in our courts that our narcotics officer can come in and testify that in his opinion something was in fact cocaine for the purposes of proving that it was cocaine, even where there has been no chemical testing. In fact, there was a case, People versus Sohnleitner, that I was just thinking of as I was listening to counsel speak, where cocaine was flushed down the toilet before the narcotics officer could seize it. And he testified that in his opinion it was cocaine, and the court held that that was fine. Somewhat analogous to the issue we're doing here. So we do allow people to express opinions that are not based upon scientific tests or evidence, that are far more subject to dispute than the kind of scientific evidence that we want to put in, yet that is allowed. And the ambiguities of those opinions and the fallibility of those opinions is an issue of weight for the fact finder. We don't have to be overly concerned in our system of law of trying to shield the jury from this kind of information when they're going to hear both sides. They're going to hear what kind of false negatives you can have. They're going to hear under what conditions you can get an erroneous result. And they're going to hear the kind of experience that Dennis Fung has had in using these tests and the problems with the tests, which he is qualified to speak to because he is aware of the kinds of things that create false positives, and he has looked at some of the literature in this regard. Now, to address the California law just very briefly on the issue of forensic blood testing or presumptive blood testing, we do believe that Coleman is dispositive, and all they are saying is that, yes, these do come in, yes, there is a history of them coming in, but you have to have evidence as to what test you're using. Because in that particular case, it was a police officer, not a criminalist, and all he said is that it was a heme stick or hemo stick, and no one knew what that was, or the Supreme Court couldn't make any decision as to what that was. But we know very clearly that phenolphthalein is one of the oldest tests. It goes back all the way to 1909. It's the most specific test, according to the literature. It's based upon the same principle as the rest of the presumptive tests, including the ones that the defendant's own experts used. And very clearly under California precedent, it should be admitted. And any issues as to the ambiguity go to the weight of the evidence, and that's a jury issue for them to resolve.
But don't I have a 352 problem that if it's only a presumptive test that hasn't been confirmed and that it's can be triggered by commonly occurring substances as well? And given that this is likely to turn out to be a circumstantial evidence case, I mean, isn't that really a waste of time?
Well, we're obviously spending more time litigating the admissibility than the evidence would take to come in. The kinds of things that could create a false positive are vegetable peroxidases, which are found in a number of vegetables, common vegetables, including apple. But
Not likely to be in a bathroom drain.
right, exactly. I mean, unless maybe he was pouring apple juice down the drain. There are also a number of other chemicals that are not commonly household chemicals, and this would be the subject of Mr. Fung's testimony. But even as to the vegetable peroxidases, it's very clear that while it is theoretically possible to get a false positive, that an experienced criminalist can distinguish between a false positive and an actual positive, because what evidently happens is it does turn pink, the same pink color that a true positive would, but it's much slower. And this is also documented in the scientific literature.
What about common household bleach, though? Which one would use in
I don't believe that,
Common.
and I may be mistaken about this, but I'm not sure that bleach was one of the items that could result in a false positive.
the article that you submitted to me indicates that bleach is one of the chlorine bleach is one of the items that can create a false positive, which is not uncommon in bathroom fixtures.
Yeah, according to Professor M. Winkreed, he does say that. Of course, this isn't a scientific text, but it's a legal text. And as I said, there are other things that do cause false positives, but, and maybe perhaps we could clarify this point with Mr. Fung, because I don't know if I specifically asked him about bleach as opposed to vegetable peroxidases. I don't recall having done that. But I do remember his explanations to me about the vegetable peroxidases, and I can't represent to the court that his explanation would be the same with respect to bleach.
Well, how do we compare the case law here in Coleman with the case law dealing with luminol?
California case law dealing
Yeah.
with luminol?
Yes.
Which case is the court referring to?
Out of curiosity, why we're not, I can't find the case at the moment.
Your Honor.
But let me ask you this, why were no follow-up tests done on these items?
What are you going to test to follow up? I mean, in order to collect a stain, there has to be something that you can see, according to my understanding. And there are certain instances where the only evidence you're going to have is the phenolphthalein test. Another instance where we have that, for example, is on item number 11,
All right.
which was the wire.
Now, let me ask you this. Wouldn't the better practice have been to take the trap out of the plumbing fixture?
I think that he may have taken the trap out, according to what we saw, and I don't know if that would be the better practice. I'd have to.
Was that tested?
Excuse me?
Was that tested?
I don't think so. Or there was. Let me take a look. There was. I'm sorry. There was a test on that, and the trap itself was negative. I mean, so the only that's the evidence that we have. I mean, we looked for evidence, and the only evidence that we have
So isn't it
is the
logical that if
phenolphthalein.
blood was being washed down the sink, that more of it would be in the trap than on the rim of the sink?
I'm not a plumbing expert, Your Honor, so I can't answer that one. I was informed by someone who apparently knows more plumbing than I that you don't make drain pipes out of copper. I don't know that to be true, but that's what someone told me. Getting back to the luminol question that the court asked, I'm not familiar with the California cases the court has cited. I'm familiar with some out-of-state cases
All
that
right.
deal with that. But can I just make one more point about luminol? Luminol isn't as specific, nearly as specific as phenolphthalein, and there is literature to document that fact. And the point that I was trying to make yesterday when I was talking about the two-stage process is that you did not always have two stages on the phenolphthalein test. When it was first invented in 1909, I believe that they just applied the phenolphthalein solution, if I'm not mistaken. They now add the hydrogen peroxide, and evidently that is supposed to deal with and negate some of the problems that you'd otherwise have with the vegetable peroxidases.
All right, thank you,
And that
counsel.
distinguishes it from luminol.
All right. Nope. Proponent, opponent, opponent. All right, counsel, as to I'm going to direct the prosecution to cover up the two photographs on the exhibit. All right, the two items that were missing, that were agreed not to be introduced were the airline ticket and what, a baggage tag?
Your Honor, may we have a few moments just to patch that exhibit, because as the court knows, I didn't want to deal with that.
All right.
there's been specific evidence of it, such as item number 14 and item number 12 inside the house.
No, they would do that at the peril of opening the door to all these other things.
The question was, we cannot argue or suggest in questions that there's no blood in the places where they did the tests. Okay. Other places where there's plainly no blood, we can bring up.
You can bring that up.
Fine.
But if you create a false impression
Right.
that that was not tested,
Oh, no,
then you open the door to
Really,
all manner of mischief.
Yep.
No.
You see, Your Honor, the problem is that what they're intending to do and what they've already done is to create a false impression. Because what they're going to say is that the only places where we have evidence of blood are 14 and 12.
If they argue that, then you get to reopen your case. They won't argue that. Don't create false impressions.
Right. But we can argue that, for instance, they did a phenotest some other place and it was negative.
Correct.
Well,
Thank you.
of course, allowing the negative phenotype.
Counsel, your own authority says that the absence of a positive phenotest is conclusive that there's no blood. That's the authority you've cited to the court.
I was inquiring.
This is not a quid pro quo. Let's proceed. Ms. Clark, I've already ruled on this. We're not arguing this.
I was not allowed to address the proposed instruction. This is the first time I'm seeing
Excuse me,
it.
counsel, but I thought we had complete argument on both sides on this issue. We have, trust me.
We had argument, but this proposed instruction is just now being shown to me. Are we allowed to address this issue of whether the proposed instruction is correct or fair?
Counsel, you had more than ample opportunity to address it.
How's that, Your Honor? This is the first time I've seen it. How could I address something I've never seen?
Counsel, during the course of the argument, Dean Ullman asked for this instruction. Then Ms. Lewis was given the opportunity to respond. Here we are.
And Mr. Ullman then wrote down what he proposed that the court actually give with respect to a luggage tag of no prejudicial value at all. I mean, we are losing perspective here, and I've never seen the proposed instruction he just wrote until this moment. We have not had a chance to address it.
Counsel, you had the opportunity to address it. Would you return it to the court, please? Thank you. Let's have the jury. Some of you are still smiling. My apologies to you for having kept you in the small jury room for such a long time. And I want to advise you that I'm going to change our procedure in dealing with so many of these pretrial matters that I have to take up before we invite you to join us. I'm going to schedule all further hearings on these type of matters at 4:30 at the conclusion of the court day, so that we'll get more time in front of you as far as the jury is concerned. Yesterday, something occurred at the conclusion of the court day that I need to instruct you regarding. The laws governing criminal procedure here in the state of California require the exclusion of evidence that was unlawfully acquired by the police. These laws exist to protect the privacy of all citizens by deterring unlawful police conduct. Prior to the trial of this case, the prosecution agreed that some items of evidence, specifically the airline ticket and baggage tag, would not be offered into evidence at trial. During the testimony of Mr. Fung yesterday, this agreement was violated. You shall therefore disregard the testimony of Mr. Fung regarding the airline ticket and baggage tag. You must treat it as though you had never heard it. All right, let's have Mr. Fung. All right, Mr. Fung, would you resume the witness stand, please? All right, good morning again, Mr. Fung.
Good morning.
Mr. Fung, you're reminded you are still under oath. Mr. Goldberg, you may continue with your direct examination.
Thank you. Good morning. Before we get into the issue of the evidence processing, once you got back to the lab, I wanted to clarify a few things that occurred earlier on the day of the 13th. Can you tell us, Mr. Fung, what time it was that you left Rockingham for Bundy on the 13th?
I left Rockingham for Bundy at approximately 10 o'clock.
And when did you arrive at Bundy?
I arrived at Bundy at 10:15 in the morning.
Okay. Now, when you returned to Rockingham in the afternoon, did you have occasion to see stain number 8 again that afternoon, the same one that you'd seen earlier in the morning?
Yes.
And was there anything different about the stain when you saw it in the afternoon than when you'd seen it before?
Yes. In the morning, the stain was a reddish color, and when I returned in the afternoon, it was a dark brown color.
And is there a distinction between red and brown in terms of the age of the stain in your mind?
Yes.
I mean, what happens when it starts aging a little bit?
When a stain ages, it starts to degrade.
Okay. So it had turned brown by the time you had returned.
Yes.
Now, regarding the stains that were collected at Rockingham in the morning of the 13th, were there any of those stains which you did not personally see being collected?
When I refer to my notes?
Yes.
I did not personally see stains 7 and 8 collected.
Had you seen them, though, prior to the time that they were collected and during the documentation phase?
Yes.
All right. And at Bundy, were there any stains there that you personally did not see collected?
Yes.
What stain or stains?
Would be stain item number 52 with the photo ID number 117.
Was 52 the stain that was at the end of what you referred to as being the trail?
Yes.
Okay.
You may. Counsel, the request was to see what he's referring to, not to have a private conference. Proceed.
Sir, what document were you referring to in order to provide the answers with respect to the stains that you did not personally witness being collected?
I referred to a crime scene checklist, and I also have some other notes that I have created for easier testimony in my notebook.
Okay. And when you were testifying about stain 52 at Bundy, I can't recall whether you may have already testified to this, but did you participate in documenting and measuring where that was?
Yes, I did.
Okay. With respect to the stains that were collected at Bundy on July the 3rd of 1994, when were those booked into evidence in LAPD? Do you have to refer to something to give us the date?
Referring to my property report,
Tell us the date of the property report you're looking at in order to give us this information.
the date of the property report is July 5th, 1994. And the items were booked into the evidence control unit of SID at July 5th, 1994.
Okay. And when you book something into the evidence control unit, is it sealed prior to that time?
Yes, it is.
And regarding item number 9, the glove that you discussed yesterday in your testimony, did you see any stains on the paper bag into which it was placed?
No.
Okay. Did you see any wet blood in the area, excuse me, did you see any wet or dry blood in the area where that glove was found?
I did not observe any.
Your Honor, at this time I'd like to put up the Rockingham diagram just briefly.
So,
That would be Peoples 169.
good thing there's no wind in this place.
Mr. Fung, I'm directing your attention to what's been marked as Peoples 169 and is titled Rockingham Interior Biological Evidence. Did you have the opportunity to look at this exhibit prior to the time it was brought down to court?
Yes.
Right. And directing your attention to the call-out number that says 14, what does that show? What area of the residence is that showing?
That is in the master bathroom.
Okay, so that would be depicting the upstairs of the house?
Yes.
And what do the photographs that are attached to item 14 show?
The photograph on the right depicts Criminals Mazzola displaying the results of a phenolphthalein test. And the photograph on the left is a close-up, and you can see the stain here.
Okay, you're pointing to an area that's just to the right on this photograph, about 1.5 inches or so from the card.
Yes.
And is the other photograph to the left simply a perspective shot demonstrating the same general thing?
Yes.
Now, directing your attention to the item call-out number 13, what general area is being pointed to there with that call-out line?
That is the master bedroom.
What about the two photographs that attach to that call-out line? What do those show?
Those two photographs show a pair of dark-colored socks on the throw rug.
Those are the socks that you recovered and listed as item 13.
Yes.
And now finally directing your attention to the call-out line that says 12, what general area of the house is that pointing to?
That is, those two photographs depict the foyer of the house, which is the entrance, and there are 3 large stains on the floor, and that is, a close-up of that is shown in the right picture.
So the right picture is simply, or the left picture rather, is simply a perspective shot showing the same general item as the picture on the right.
Yes.
Thank you. Now, we had left off yesterday with you going back to the laboratory, and I believe you testified that you arrived at approximately 6:30, is that correct?
Yes.
Right. Now, when you went back to the laboratory, were you still wearing the same gloves that you had, that you would have been wearing at the time that you left Rockingham in the afternoon?
No.
What process do you go through in the laboratory when you're returning to the lab with biological evidence?
With biological evidence, there's a drying process that type of evidence is subjected to.
Your Honor, at this time I'd like to mark as Peoples 170 for identification another board, and I believe it's entitled Evidence Drying Demonstration.
All right, People's 170.
Yeah. Sir, directing your attention to the board that we've labeled 170, perhaps we could see the first photograph on that in cell 1.
Pupils?
Sir, what does that show?
The first photograph depicts the door to the evidence processing room.
Okay, and is that that's an interior door?
Yes, it is.
And EPR stands for Evidence Processing Room.
Yes.
Is there any other door that you can take into that particular room?
Yes, there is.
Which door is that?
That is the rolling door that faces towards the outside of the facility.
And in order to get the rolling door up, do you have to go through this door?
Yes.
indicating the door that's depicted in cell number 1?
Yes.
Right. If you look at this picture in cell number 1 to the right of the door, there appears to be some sort of a plastic or glass-like object. What is that?
That is a marker to let people know where the most sensitive part of the sensor for the keyless entry is.
So is this like a card key type entry system?
Yes.
Right. Was Andrea Mazzola still with you during the trying process that occurred on the 13th?
Yes.
Right. Now, let's take a look at a photograph in cell 2. What does that photograph depict, Mr. Fung?
The photograph depicts the transferring of a cloth swatch in a plastic baggie to a labeled test tube.
Your Honor, at this time I'd like to mark a test tube as Peoples 163. G.
163G.
Sir, I'm showing you what's we just marked as 163G. What is that item?
This is a disposable test tube.
And I'm going to take a item that we've previously marked as Peoples 163E for identification. It's one of the plastic bags contained in that coin envelope. You testified that this was the type of plastic baggie that you use when you're at the crime scene.
Yes.
Can you just show us how it is that you're manipulating the evidence as is depicted in cell 2 by using the test tube and the plastic baggie?
Yes. Well, first I would have gloves on, as is depicted in the picture. The cloth swatch would be within the bag. I would place the test tube in the plastic bag and manipulate it into the test tube.
Okay. So your hands never come into contact with the swatch itself?
That's correct.
Is that the procedure that you used on the 13th in terms of drawing?
Yes, it is.
And who did all of those manipulations? Was that you or was that Andrea Mazzola or a combination?
Ms. Mazzola labeled the test tubes, and I did the actual manipulation of the cloth swatches into the test tubes.
So all the manipulations you did.
Yes.
Now, when you say labeled the test tubes, what kind of label is put on there?
The same number that is placed on the coin envelopes are placed onto the test tubes.
How many coin envelopes do you work on at a time when you're doing this procedure?
Only work on one at a time.
Okay. And what happens to the control that's in that corresponds to the stain in a particular evidence, not evidence, but coin envelope?
The control is treated in the same manner and placed in its own test tube with the number and the letter C next to it, denoting that it is the control for that item of evidence.
Is it generally easy to recognize the difference between the control and the stain, even without the reference to this letter C?
Yes.
Why is that?
Generally, the cloth swatches that have the stain on them are dark red in color, and the controls are not red. They're either white or very close to gray or white.
Now let's take a look at the cell that's number 3 on this diagram, Peoples 170. Mr. Fung, what is portrayed in this cell?
Once both the control and the item with the stains on them, or the cloth swatches with the stains on them, are transferred to the test tubes, both the control and the evidence is placed back into the original coin envelopes with the open end faced outwards and placed into a box top.
I don't know how good the resolution is on cell 3, but if you take a closer look at that, can you see how many test tubes are in the envelope that's being placed down by the glove hand?
Yes,
How many is that?
there are two.
Okay, so one would be for the control and one would be for the stain.
Yes.
Now, if you have more than one stain cloth swatch in a case where you applied several in order to collect the stain, where do all those go?
All those go within one test tube.
Okay, so you have one test tube that has all of the stain swatches
Yes.
and one test tube that has the control or controls.
Yes.
What is the purpose of this box that the item is being placed into?
The box is used for storage of, or a transitory storage stage to move from the table to the drying cabinet.
Okay, now let's take a look at cell number 4 on People's 170. What does this show, Mr. Fung?
That depicts me placing the box with the items of evidence into the drying cabinet.
Okay. And on the 13th, did you use this same procedure that you've just outlined with us using this demonstration exhibit?
Yes.
Right. Thank you. Now, after the items are placed in the storage cabinet for drying, what did you do?
That night, after the samples were prepared for drying, I went back to Northeast Station where my car was.
Did someone have to drive you there?
Yes,
Who was that?
that was Criminals Missoula.
Do you know approximately how long this drying process occurred before Ms. Mazzola drove you back to Northeast Station?
Not more than 10 minutes.
Now, sir, on June the 14th of 1994, at approximately 8:30 in the morning, did you receive another piece of evidence from someone?
Yes, I did.
And who was that? If you have to refer to something, tell us what you're looking at.
I am referring to my property reports.
To go through any procedure with respect to the swatches and controls that have been placed in the drying cabinet?
Yes.
And what procedure did you have to go through?
I had to prepare the samples of the cloth swatches that I have dried overnight for final booking.
Your Honor, at this time, I'd like to mark another demonstration board. It will be People's 171, and it's a board entitled Evidence Packaging Demonstration.
Right, People's 171.
Now, sir, when you went through this evidence packaging procedure, did you do this alone, or did Ms. Mazzola also assist you with this? On the 14th, rather.
Ms. Mazzola may have been present, but I'm not absolutely sure.
Okay. And directing your attention now to the board that's been marked as People's 171, does this depict most of the major steps that are involved in packaging evidence up once it's been dried?
Yes, it does.
Okay. Can we look at cell number 1 on this photograph? Okay. Sir, can you describe for us what's depicted in cell number 1?
Yes. Using a disposable pipette, I am manipulating the cloth swatches so that they will fall from the test tube onto a clean sheet of paper.
Your Honor, at this time I have another item I'd like to mark. As People's 163 F for identification. And it's some, what appear to be glass pipettes.
All right, 163F.
Unfortunately, they're both taped together
We'll
with
call
the
them-
evidence tag. Is it possible for me to break the tag so we can,
Yes,
thank you.
just as long as you describe for the record how many are there, and
Well, there's 2 of them, and they're taped together with an evidence tag.
fine. Why don't you leave the evidence tag on the single?
I did.
All right, thank you.
Sir, I'm showing you what we just marked as 163F for identification. What is that?
This is a disposable glass pipette.
Okay, I'm going to give you back the little test tube that we were working with. That's 163 G for identification. And can you just show us, as if there had been a swatch in there, what manipulation is shown here on the photograph that you're doing?
Sometimes when the swatch with the stain on it dries to the side of the test tube and it sticks there. So I'll take the pipette, work the swatch free, and then turn it over onto the paper so that the swatch will fall onto the piece of paper.
What do you call the piece of paper that you're putting the swatches on as depicted in cell 1?
And once I fold it up, it's called a bindle.
So do you always have to use a glass pipette in order to do this manipulation, or is it just necessary some of the time?
Just some of the time.
All right. And if you don't have to use the glass pipette, how would you do it?
I would turn the test tube upside down onto the paper, and sometimes it just falls right out.
And then you fold up the spindle in the way that you described.
Yes.
Now, if we could see cell 2 on this exhibit. Mr. Fung, what is depicted on cell 2 of the exhibit?
In cell 2, I am throwing away both the test tube that contained the cloth swatch and the pipette that I used to remove or manipulate the swatches within the test tube.
So when you're saying you throw it away, do you use one pipette for each sample on those instances where you have to use the pipette and then throw it away? Or is it the same pipette used throughout the whole?
It's a different pipette for each sample and control.
And all those pipettes are just thrown out?
Yes.
And the test tubes?
Yes.
Okay. Now if we could see cell 3. Sir, what does cell 3 depict?
Cell 3 depicts me folding the paper up so that the swatches are secure within that piece of paper.
Okay, so would that piece of paper be the same one that you had placed the swatches into originally as depicted on cell 1?
Yes.
And now if we could see cell 4. Sir, what does cell 4 depict?
That depicts me labeling the paper bindle.
And what do you label it with usually?
Usually, I will place my initials on it and the item number or photo ID number, whichever I have at that time.
Do you do something to distinguish between the stain and the control?
Yes, I do.
Okay, so if this is a single item that we're looking at in this demonstration, do you put the stains in one bindle, and then what do you do with the controls?
With the controls, I will repeat the same procedure starting from number 1 and repeat the same procedures, only I will label the paper bindle with a C.
Okay, so in other words, you're going through all the steps with the stain, and then you're going through all the steps again with the control?
Yes.
Right. Now, if we could see cell 5. What is depicted in cell 5?
Cell 5 shows me placing both the bindles in a coin envelope and placing tape over the flap so that the item is secure.
And what coin envelope is this? Is this a new coin envelope?
Generally, it's the same coin envelope used from the very start when the plastic bags were placed in them.
So in other words, it's the same coin envelope that you used at the scene and then in the drawing process and then again in the evidence packaging process?
Or
Yes.
Okay, thank you. Thank you, Mr. Fung. You may resume. Stand. And as what we just went through the drawing process that was used in this case for the items of evidence that were collected on the 13th and then also on the 3rd of July.
Yes.
All right. Now, later that morning, the morning of the 14th, did you have a conversation with any other laboratory personnel regarding tests to be performed on the evidence that you had collected at Rockingham and Bundy?
Yes.
Who was involved in that conversation?
Criminalist Yamauchi and criminalist Greg Matheson.
Who is Greg Matheson?
Mr. Matheson is, or was, at that time, the supervisor of serology. He is now a chief forensic chemist.
And what about Mr. Yamauchi? What was his position in the laboratory at the time?
Mr. Yamauchi is a criminalist assigned to the serology unit.
Do you recall where physically this conversation took place in the laboratory? Or did it take place in more than one place?
I'm not exactly sure where it took place.
Okay. Now, during this conversation, was a determination made as to what items were going to be tested on that particular day by Mr. Yamauchi?
It was a group consensus, and we all came to the conclusions as to what items would be tested.
And the three of you were the only participants in that discussion?
Yes.
All right. Now, which items, if any, did, excuse me, let me ask another question first. Did you see Mr. Yamauchi sampling some items of the evidence that morning?
I remember him sampling evidence, but I don't recall on which day it was.
Okay. And did you make a notation in your report as to what items were handed over to Mr. Yamauchi on the 13th for the purposes, excuse me, on the 14th for the purposes of testing?
Yes, I did.
Can you tell us which page you're going to have to refer to in order to give us that information?
There is a page, doesn't have a date or anything on it. Well, it does have one date on it, 6/14/94, and the top of it is labeled field notes.
Okay. What items did you give to Mr. Yamauchi? And if you will, can you give us the item numbers as well as the photo numbers?
The items I gave to Criminalist Yamauchi, or the items that Criminalist Yamauchi sampled that day were item 9, 41, which was photo ID number 106, item 42, which was photo ID number 107, item 47, which was photo ID number 112, item 48, which is photo ID number 113, item 49, photo ID number 114, item 50, photo ID number 115, that's 115, and item 52, which was photo ID number 117.
Now, do you recall why it was that you decided to give him item 41 and 42? I think those were the reference samples that you testified to yesterday.
Those were given to him for the testing procedure because we had not yet obtained reference samples from the coroner's office.
You mean from the victims?
Yes.
Right. So for what purpose then would you be giving him, if you can clarify, 41 and 42?
41 and 42 were given to him so that he could identify what types the victims were and determine if any additional bloodstains found at the crime scene were from a third party or
And
more.
did you say that was because you did not have the samples from the coroner yet representing Ronald Goldman and Nicole Brown?
Not at that time.
Okay. Now, I know we talked about this a little yesterday, but did you say that these items were taken as reference samples at the time that they were collected?
Yes.
And why is it, if you know you're going to get blood eventually from the coroner, why would you bother taking a reference sample at the scene?
There are times when the reference samples obtained from the coroners are somewhat degraded, and many times the blood at the scene, which has been able to dry quickly, is a better sample, or yes, a better sample of the victim's blood types.
What does drying quickly have to do with it?
When blood, or for any matter, biological evidence is in a wet state, it will degrade faster than when it is dry.
Okay. And with respect to item 42, the item that was collected at the base of the first set of stairs, what was the condition of that pool of blood in the area where it was collected from?
The pool was somewhat tacky. It was somewhat wet still. It was not completely dry.
Okay. At the time that it was collected?
Yes.
Now, at approximately 10:30 or so in the morning of the 14th, did you go to some other location for the purposes of collecting evidence?
Yes.
And where was that?
That was at the LAPD print shed.
And where is the LAPD print shed located?
That would be 151 North San Pedro Street.
So it's in downtown Los Angeles?
It's across the street from Parker Center.
All right. When you went to that location, did you have to get into the print shed, or was it already opened?
I unlocked it.
How did you unlock it?
I had a key.
All right. And what did you see in the print shed when you unlocked it?
There was a white Bronco in the print shed.
Have you seen that white Bronco before?
Yes.
And where had you seen it before?
I had seen it the day before at 360 North Rockingham.
What was the license plate of that vehicle, Mr. Fung?
Referring to my vehicle search checklist, that would be 3, C as in Charles, W as in William, Z as in Zebra, 788.
When you got into the print shed and saw the vehicle, did you try to get in somehow?
I had to, or a detective from Burglary Auto Division was requested to help us unlock the door.
Did you have a key to the vehicle at that time?
No.
That was locked when you first saw it?
Yes.
Was it also locked at the scene when you'd seen it on the 13th?
Yes.
All right. And how was it that this detective helped you get in the vehicle?
He had a device which is known as a Slim Jim, and he was able to unlock the car door.
All right. Now, when you were at this location, did you go alone, or was another criminalist with you?
Criminalist Mazzola was with me.
Did you collect some stains from the Bronco on this date, the 14th?
Yes, I did.
And when you collected those, did you do that personally, or did Ms. Mazzola also collect some stains?
I collected them personally.
All right. Your Honor, at this time, I'd like to mark as my next exhibit a board that says Bronco board, I believe, as 172 for identification.
172, Bronco board.
Before we get into the board, I just wanted to ask you a couple other questions. When you got to the print shed, this was on the 14th,
June 14th, yes.
and that was that the day that the detective opened up the locked Bronco with the Slim Jim?
Yes.
Okay. Now, have you had the opportunity to look at the board that we've just put up, People's 172 for identification, entitled Bronco Evidence?
Yes.
All right. And does this depict various items of evidence that you collected on the 14th?
Yes.
Does it also depict some items of evidence that were collected later on by someone other than yourself?
Yes, it does.
Perhaps we'll just go around clockwise, starting with the photo that contains item 34. You don't? Okay. Fortunately, we're not going to be able to put it up there, but directing your attention, sir, to item 34 for identification. I mean, item 34 with the card. What does that depict?
That depicts a stain which was next to the card. You see it right here.
Is that on the inside of the car?
Yes, it is. It's on the driver wall.
All right. And does the call-out line that has line 34 on it depict the general location of that stain?
Yes.
It would be on a portion that we can't see on the sketch.
Yes.
All right. I'm not sure that all the jurors can see the board, Your Honor. Perhaps we can just readjust it a little bit. Your Honor, perhaps we could move this in a fashion that's a little bit more centered with the court's permission. Okay. Now, sir, directing your attention to the cell that has the call-out line number 23 on it. What is portrayed in that call-out line and the photo?
In the photograph, there is a red stain in the handle well.
Okay. And does the call-out line depict the general vicinity of that stain?
Yes.
Now, with respect to these two stains, 34 and 23, how did you collect them? What technique did you use?
Those were collected using the same method previously demonstrated.
The cloth swatch technique?
Yes.
Right. Now, directing your attention to what's been marked here with the photograph 33 and the call-out line, what does that show?
I'll refer to my notes. "33 depicts the driver floor carpet."
So it's the carpet itself.
Yes.
And what did you do to collect that?
I cut it out of the vehicle.
All right. Were there stains on that were apparent to you when you looked at it on the 14th?
Yes.
All right. Now, moving to the call-out line that's number 24 and the corresponding photograph, what's depicted there?
This depicts a stain that was on the instrument panel. And its relative location is depicted by the call-out.
Okay. What technique was used to collect that stain?
The cloth swatch method was used.
And 33, is that another photograph that appears to depict the area of the carpet?
Yes.
All right. And now, moving next to 33 with the call-out line number 29, what does that photograph and call-out line depict?
29 was a stain removed from the 7 o'clock position of the steering wheel.
What technique was used?
The cloth swatch method.
And now directing your attention to the photograph that depicts both 31 and 30 and the call-out lines, what is shown there?
There are two stains on the center console, and they're depicted and shown by the call-out lines.
Now, did you remove the console itself from the vehicle, or was that done by someone else?
That was done by somebody else.
And looking at the photograph that's depicted at the bottom of the chart on the right-hand side that has numbers 304, 305, and 306 in it, did you put those numbers there, or did someone else do it?
Somebody else did that.
Do you recognize the item that's portrayed in that photograph?
The center console?
Yeah.
Yes.
How do you recognize it?
The same general stains are present.
All right. Does that look the same as it did on the 14th, with the exception that it's been removed from the vehicle?
Generally, yes.
And also the photograph next to that depicts 293. Is that one that you did, or is that something that happened at a later time?
That happened at a later time.
Okay, and finally, the photograph next to it showing the call-out line number 25.
25 was a, oh, check my notes again. Number 25 was fibers with red stains on the carpet.
What technique did you use to collect those stains?
I cut the fibers that had the stains on them from the carpet.
Okay. And does the call-out line there depict generally the location in the carpet where it was found?
Yes.
Your Honor, perhaps we might be able to move this. I'm finished with it now, but just so the jurors could see somehow.
All right, Mr. Fairtlow, you want to show 1492, the exhibit? Also, Mr. Fairtlow, would you briefly show it to our audience? All right, we'll take our recess for the lunch hour. Ladies and gentlemen, please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to talk to you about the case. Do not conduct any deliberations till the matter has been submitted to you. See you back here at 1:30. Mr. Fung, you may step down. You're ordered to return 1:30. Thank you, sir. Thank you. Just stand, please. All right, let the record reflect we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Almost an on-time start. All right, Mr. Dennis Fung is still on the witness stand undergoing direct examination by Mr. Goldberg. Good afternoon again, Mr. Fung.
Good afternoon.
You're reminded you are still under oath, sir. Mr. Goldberg, you may continue with your direct examination.
Thank you, Your Honor. Sir, we were talking about the search of the Bronco when we left off. Did you recover any physical items of evidence in the Bronco other than the stains that you just referred to in the way of clothing?
Yes.
What was that?
I collected a cap.
Where was the cap collected from?
The cap was recovered from the driver floorboard.
Your Honor, at this time, I'd like the witness to take another look at People's 164 for identification. It was the box. May I approach the witness?
Yes, you may.
Sir, showing you 164 for identification. Could you unseal that and describe what you're doing for the record?
Cutting along the bottom edge of the box. And through the tape. Within the package are several bags. The first one I'm pulling up is Item number 27.
Okay, and is that the bag into which you placed the cap?
Yes, it is.
And you also put the DR number in our case on there?
Yes.
All right. Sir, perhaps you could unseal people's 160, perhaps we can mark that as 164C, Your Honor, just so the record is clear.
All right, 164C will be the paper bag marked as item number 27.
And could we mark the glove 164A and the blue bag 164B?
All right, Mrs. Robertson, do you have that? All right, thank you.
I'm cutting along the seal. Unfolding the bag. And within the bag is a cap.
And is that what you collected?
Yes.
Okay, can you now replace the item describing what you're doing for the record?
I'm placing the cap back in the bag and folding the bag up and placing the cap back into the box.
Now, after you'd collected the various items of evidence from the Bronco, where did you go?
After collecting the items of evidence from the Bronco, I returned to the crime lab.
With items that you had collected?
Yes.
And was the Bronco secure when you left?
The Bronco was left in the print shed, and the print shed was locked.
Okay. When you went back to the crime lab with the items, did you go about processing them in terms of the drawing process that you have previously described in your testimony?
Yes.
Now, on this particular occasion, do you remember what role, if any, Andrea Mazzola played in terms of the drawing process?
She removed some of the samples from the plastic bags and placed them in the test tubes to dry.
Using the technique that you had described, or do you recall whether she used a different technique?
She used the same technique.
All right. And what was done with the evidence after it had been placed into the bags, had been placed to the test tubes to dry?
After being placed in the test tubes to dry, they were placed in the drying cabinet within the evidence processing room.
All right. Now, directing your attention to the afternoon of June the 14th, after you came back and did this processing with the Bronco evidence, did you remain at Piper Tech?
Yes, I did.
And what were you doing there that afternoon?
I continued to write my property reports from the previous 3 scenes that I had done.
Now, with respect to the, excuse me. With respect to the vial of blood that you had received from Detective Van Adder, was a property number assigned to that vial of blood?
Yes.
And who assigned that? Was that done by you?
Yes,
or
it
by-
was. Yes, it was.
All right. And can you describe for us how that process occurred of assigning the number to the vial of blood?
I had items of evidence numbered up through 16. I had received the vial of blood at Rockingham the afternoon before, and I decided to make that item number 17.
Your Honor, at this time, I'd like to mark as people's next in order 173, a Xerox copy of laboratory note L115, and it has numbers 17, 18, excuse me, L15 was the laboratory note. And it has items 17, 18, and 19 listed.
I would like the original of that, which I believe is in court, marked as well. He can use the copy, but I'd like the original marked as a separate item.
Well, he's entitled to run his own case. If he wants to use a Xerox copy, he can use a Xerox copy for this purpose. If you want to use the original for cross-examination, you're entitled to do so. Proceed. Be marked as 173.
Your Honor, may I put this up on the Elmo?
Yes.
Sir, we're going to show you what's been marked as People's 173 for identification. Do you recognize this page?
Yes.
And who wrote that out?
That was written by Criminalist Mazzola.
Okay. And did she write that out at someone's direction? Or did she do it on her own? Did you tell her to, or did she do it on her own?
I believe she...
What's the objection?
I don't think he has a proper foundation with respect to personal knowledge of...
Rephrase the question.
Did you tell her to?
No.
All right. And when was the first time you saw this document?
I saw it while I was writing my property report.
Okay. And what did you do when you saw this document?
I had her transcribe the information onto an evidence collection report.
Okay, this was just written on a blank sheet of paper?
Yes.
And do you have standard forms that are used in the ordinary course of the crime laboratory's business for the purposes of writing out items of evidence that were obtained during a crime scene investigation?
Yes.
All right. And is the crime scene identification checklist that we saw yesterday one of those forms?
Yes.
Your Honor, I'd now like to mark as People's 174 for identification. Another document, I'm going to put a 174 in the upper left-hand corner. I can't read the L number on it, but I'm showing it to counsel.
All right, 174. This is another lab note.
Yeah, and it has 18, 17, and 19 on it. Can we put that the other? Okay, now, Mr. Fung, directing your attention to 174, what is this document?
This is the evidence collection report that the information was put on or transcribed to.
When you say the information, are you talking about the information from the last document we saw, 173?
Yes.
And who put it on this form?
That was a combination of myself and Ms. Mazzola.
Okay, and on this form, what was the number that was assigned initially to the blood vial that had been received from Detective Van Adder?
Initially, the item number was 18.
And that was what Ms. Mazzola had put on the other form?
Yes.
And what was item number 17?
Item 17 was a pair of tennis shoes.
Okay. Now, when Colin Yamauchi collected his evidence earlier in the morning of the 14th, do you recall whether he was given a number as to the reference sample of the defendant's blood?
I don't recall.
Or roll.
I don't recall.
All right. Now, at some point, did you decide to reassign numbers to these, to the tube?
Yes.
And why did you make that decision?
I wanted to keep the items in a chronological order and reduce less paperwork for myself.
Okay. Now, why would it reduce the paperwork?
If the blood had remained item number 18, I would have had to create 3 additional property report face sheets.
Okay. Now, with the pair of sneakers on the previous document that we saw was labeled item 17. Is that correct?
Yes.
And which did you receive, and the blood 18?
Yes.
And which did you receive first, the blood or the pair of sneakers?
I received the blood vial first.
All right. And do you try generally to keep items in chronological order?
Generally, yes.
Okay. In order to do that, did you need to reassign those numbers?
Yes.
Now, I wanted to follow up on this other question that you said about reducing the paperwork. What is the type of paperwork that you would be reducing?
Property report.
Your Honor, may I mark as People's 175 for identification a property report that has the date of, well, rather than identifying by date, I'll do it by number. It's number 12 through 17. And I have another property report, which I'd like marked as People's 176, that has number 18 and 19 on it.
All right, so mark 175, 176.
One, please. Okay. Sir, looking at this document, do you recognize this?
Yes, I do.
And who filled that out?
I filled it out.
And is number 17 way at the bottom the reference to the vial of blood?
Yes.
Okay. Now, can you explain to us with this exhibit why you would have had to fill out more paperwork if you had kept the blood vial as number 18 instead of changing it to 17?
When writing property reports, we are not allowed to skip item numbers from, for instance, going from 16 to 18. You have to have everything in sequential order. So if I wanted to make the blood 18, I would have had to stop at item number 16, created a new property report with 17 and only 17 on the next property report, create another property report with only 18 on it, and that's why I made the blood number 17.
Okay, let's take a look.
With the Ladies and gentlemen of the jury, would you please step back into the jury room? All right, it appears that this exhibit, I believe this is number 175, is the property report, reflects two items, the 15 and 16, which are the items that we just had the problems about earlier this morning. And unfortunately, the evidence presentation system is sufficient that I can, from the jury box, read what items 15 and 16 are. And if you recall, that's what caused me to read the sanction instruction to the jury, and now the prosecution has chosen to show this to the jury again.
I see that, Your Honor, and I did not take it upon myself to redact it. I wasn't thinking about that at all. And Mr. Scheck saw the document before we put it up, and he did not say anything to me.
Well, I don't know that it's Mr. Scheck's obligation.
It's not a question of obligations. It's a question of there was no objection, and this is a situation. I mean, what were they trying to do? Wait for something to be put up in front of the jury, and then hold back, and then make an objection, and suggest that some sort of remedial action needs to be taken when Mr. Scheck saw it. And I think that if you asked him, well, why didn't you say anything? He'd say, I overlooked it too, in all probability. I mean, what I was concentrating on was item number 17. The only relevance of this document is item number 17. And that was all my concentration was on. was item number 17 and explaining that part of this witness's testimony.
You're not making this easy, are you, Mr. Goldberg?
Well, I really don't think it's that difficult, Your Honor, in all due respect to the court. I mean, it happened.
Oh, wait.
No
We have
objection
an
was
agreement
made.
that this item is not going to be used or mentioned. You violate that agreement. I grant the unusual remedy of instructing the jury that that should not have been done. 20 minutes after that happens, and 20 minutes into the session this afternoon, you put this up on the Elmo.
Well, everything the court has said is true. I mean, the court's recitation of the facts are correct.
The first explanation is you had no idea that that had been the agreement, and the agreement had been, if this was going to be brought up again, that the defense was entitled to a de novo 1538.5 motion.
I realize that, and
And now here it is again,
because, Your Honor,
in the same day.
I recognize that. You know, it is not customary, Your Honor, for attorneys to take it upon themselves to redact documents. I realize that what should have been done here, if I had caught...
Here's the problem. The court cannot supervise the preparation of each and every exhibit. Otherwise, we'd be spending a whole lot of time just looking at exhibits. And I trust the professionalism and integrity of the lawyers involved in front of me to at least cull out the things that aren't going to be controversial. This clearly is.
You're right. And I did not take a second look at this before I used it this afternoon after the court's ruling. I mean, I just didn't think about it.
It wasn't the court's ruling. That was our agreement months ago.
Well, I meant the ruling earlier this morning. And Mr. Scheck, who saw it, did not say anything to me.
Mr. Scheck, any comment?
I think the facts speak for themselves. I'm sure Mr. Goldberg had planned to introduce this document in regard to the matter of the transfer of the blood vial in item 17. I walked over, took a quick glance. I did not think at that moment that about the airline ticket being in that particular place. That's true, but he's trying his case. It didn't occur to me till we sat down, took a look at the monitor, and I said, oh my God, there it is. I don't know what to say about that other than I don't want to try his case for him, and I suppose he has to look at the items and redact them as appropriate. The real dilemma that I actually have at this moment, and I don't know if the court wants to address it, is the issue of remedy. So whenever you want to... But that's the only comment I can make on what he said.
Well, what remedy do you seek?
We need a moment to discuss that, of course. Your Honor, in terms of the remedy, as indicated by the initial instruction that Dean Ullman proffered to the court, our concern is really with, at this point, the prosecution's violating its agreements. At this stage, what we're concerned about is it now begins to look as though we're trying to hide these items when there was an agreement they wouldn't be introduced, and now in re-instructing them, all of a sudden, the importance of this may take on greater weight in the jury's mind than it really ought to in terms of the defense trying to hide something from them, when that's not really what's going on here. What's going on here is the prosecution now twice has violated its agreements. In fact, I think in the first instruction that Dean Ullman proffered to the court, we didn't even necessarily ask for a remedy, disregard everything you've heard about that, because we do have that concern that it's going to look like we're trying to hide something from the jury. We never should have been in this dilemma in the first place. So the remedy is that we'd like you to instruct the jury that the prosecution has again violated its agreement with respect to proffering these items of evidence and violated the court's order.
Mr. Goldberg?
Well, Your Honor, the problem with these arguments is that this seems like an incredible placement of form over substance. I mean, don't you start your analysis by asking yourself, what is the prejudice here? And Your Honor may recall that one of the first questions that I posed, rhetorical questions when we were arguing this earlier, to the defense was, can they legitimately claim in good faith that this is something that is prejudicial to them, or that this is something that they might not even have intended to introduce anyway? I mean, based on what the jury has heard
Mr. Goldberg, were I in your shoes, I would be thinking about adopting an attitude that the court would be receptive to hearing.
I'm just
And
trying.
rather than cast the problem and the burden upon the other side, opposing counsel, I would be contemplating how best to salvage my credibility before the court. And I would be thinking about that I couldn't say mea culpa too many times in this situation, were I in your shoes.
I did. I said it the first time. I'll say it again, and I said during my argument, it wasn't the first time a mistake was made by the prosecution, by me, by defense counsel. It won't be the last time. I just didn't know how soon it was going to occur.
Well,
But, you know-
the fact that it occurred again so quickly is perhaps not surprising, but what's incredible, in the true sense of the word incredible, is that it would happen on the same subject matter.
Well, what I would ask the court to do, I can make a representation as to what happened. I can say this is a mistake. I can say it shouldn't have happened. I can say I am sorry. I can also represent to the court that this is not done intentionally. I don't know whether the court believes that or not. That's something that Your Honor has to decide. I know I haven't practiced in front of the court before, but I hope that based upon my representations and the way that I've tried to handle the legal issues, perhaps Your Honor is in a position to decide that. But aside from that issue, I would ask the court also to think about this just from a circumstantial, if you want to talk about evidence and legal analysis for a moment, think about it from a circumstantial evidence standpoint, which is maybe perhaps the only evidence that Your Honor feels that you can rely on if you don't want to accept my word.
Well,
And
Mr. Goldberg, I just have to say that if I were you, I would ask the court's permission to put up a redacted copy of this exhibit And I would ask permission to directly say to the jury, I'm sorry, I did it again. And move on.
Well, okay, I think that the court doesn't want to hear any more argument about it. If that is the way that the court feels it should be resolved, I would agree to that. But just so that we don't have any
Well,
problems.
somehow I get the feeling it's not heartfelt.
Well, I don't know what I can do, Your Honor. It is heartfelt. I mean, I think that the court can
Well, Mr.
imagine
Goldberg,
being in my shoes.
Trust me, I don't mean to embarrass you by this, but you got to admit it's incredible that this could happen on the same subject twice in the same day.
I do. I admit it is
All right.
incredible. And I would still ask Your Honor to think about whether or not, because Your Honor has questioned, I think, my integrity, what possible advantage I would
I didn't say that.
conceivably imagine.
I said that I would try to salvage it were I you, and I would be concerned about it.
And I am. I mean,
All right.
what else can I do? I mean, I wish the court would think about it. I'm certainly sorry it happened. I don't know what else to say.
Can I get one of our law clerks out here, please? Can I have that, please? Is this a photocopy? Don't go away. See if you can obliterate this. I'm listening.
We've talked it over, and our problem at this point is the concern I expressed before about redacting it out, is that we fear
I
that...
can tell them it's irrelevant to the case. Give me 5 copies. Make sure that what's redacted is gone. And Mr. Goldberg, before we go too much further, please accept my apologies to you if I seem irritated. But this day has not gone well. It started off with many different arguments over many contentious items, and it's been a bad day today.
I agree with that, Your Honor.
All right. So don't take it personally. But you're not making my job any easier today. All right, Mr. Scheck, you were saying you don't want to highlight this, is what you're saying?
Yes, Your Honor. I think that if I could make the suggestion that the court should admonish the jury in any way you see fit with respect to the violations of the agreement. But at this point, it seems that we don't want to bring any more attention to that and make it seem as though there's some undue significance to it. I think the jury may think, if they're twice instructed to disregard it, they may think that there's something the defense is trying to hide, and we don't want to do that at this point. So we would just...
Use a redacted copy and leave it at that?
No, we don't want to redact the copy, Your Honor. But we want the admonishment that
Oh,
it
wait.
shouldn't have been shown. And at this point, it's of...
Well, if
and
you
just
don't want to
leave
use
it
a
at that.
redacted copy, then what?
After due consideration, what we would request of the court is, yes, a redacted copy, and add an instruction to the jury that the prosecution has broken its agreement again, and a further instruction to the jury that the items there are irrelevant.
Let me show you the redacted copy and see if you think this is too obvious. Why don't you give them both a copy? I guess we ought to white it out instead of black it out.
From here, I can tell that.
Well, you know, with word processors, you don't have whiteout anymore. All right, Mr. Goldberg, I'm going to suggest that you proceed at this point without this exhibit. Mr. Fung can testify with regards to his memory with regards to these items, refer to his own reports. And if we use this item again, number 175, it will have whiteout instead of blackout, because that's just too obvious. All right, let's have the jurors. That we have been rejoined by all the members of our jury panel again. Ladies and gentlemen, the reason for our brief recess is that the exhibit that was on the evidence display system, People's number 175, made reference to two items that the court has previously deemed to be irrelevant and that the parties had agreed not to present to you. And that exhibit was shown to you by mistake, and you will not be shown that exhibit until it has been corrected to delete mention of those two items. I know that you were very diligent jurors, and I saw you looking up and reading the item. You are to disregard the mention as to items 15 and 16 if you wrote it down, read it, or recollect it. You are to disregard mention of those two items. Proceed. And I might add, you were not to speculate as to what those items were.
Okay, so at any rate, Mr. Fung, did you make a decision then to assign item number 17 to the blood vial?
Yes.
And did you then make a decision to assign number 18 to a different item?
Yes.
And what item was that?
That was the pair of tennis shoes I had received from Detective Lang.
Now, on this date, June the 14th, approximately how late would you say that you worked there at the Scientific Investigations Division?
Approximately 7:30.
Okay. And were you filling out your paperwork the whole time, or what were you doing?
I was filling out paperwork. I may have taken a couple breaks here and there.
Where were you filling out the paperwork? Do you know what room?
I was doing that in the evidence processing room.
That's the same room that the drawing process occurs in?
Yes.
Now, directing your attention to the date of June the 15th of 1994,
Yes.
did you go to the Scientific Investigations Division?
Yes, I did.
And is that also at Piper Tech?
Yes.
Did you receive some more evidence from another criminalist in the morning of that date?
Yes, I did.
What did you receive?
I received the victim's reference blood samples, or blood vials.
From the court that presumably came from the coroner's office.
Yes.
Who gave those to you?
Those were given to me by criminalist Yamauchi.
Okay. And on this date, did Mr. Yamauchi sample some more items at around 10 o'clock in the morning?
Sustained. Foundation.
Okay. Sir, to your knowledge, did Mr. Yamauchi sample some items?
Yes,
Where did that take place?
that occurred in the evidence processing room.
Did you make some notes regarding what Mr. Yamauchi sampled on this date?
Yes,
Do you recall whether you had a conversation with him as to what items should be sampled and tested, or how did that work?
best of my recollection, we did discuss what items were most relevant to the issue at that time.
All right, and can you tell us, using the item numbers, which item numbers Mr. Yamauchi sampled from on this occasion?
Mr. Yamauchi sampled items 23, 34, 25, 31, 33, 12, and 14.
After those items were sampled, what were you doing for the remainder of the day?
On
The 15th?
the 15th, I processed the Bronco evidence and continued to finish property reports.
Okay. Did you return to work on the 16th?
Yes, I did.
And what were you working on at the 16th?
On the 16th, I prepared all the evidence and checked it for final booking and entered the evidence into SID property.
When you entered into SID property, was it in a sealed condition?
Yes, it was.
And by all the evidence, you mean from Rockingham, the Bronco, and Bundy?
Yes.
Sustained.
I didn't-
Rephrase the question.
Which
They
question? The last one?
compound.
The last one?
Yes.
Okay. Did that include the evidence from Bundy
Yes.
and Rockingham
Yes.
and the Bronco?
Yes.
I still object, because that is vague as well.
Overruled. That's as obviously as of the 15th. Jury can figure that out.
I just have one moment, Your Honor, to look at my notes. Sir, I'm not sure whether I covered this, but as to item number 18, the tennis shoes, when were those recovered?
The tennis shoes were recovered on June 14th, early in the morning.
And who did you recover them from?
According to my notes, Detective Lang.
Do you recall where that was?
That was in the serology unit in the crime lab.
Was anyone else present other than you and Mr. Lang?
Yes.
Who?
Criminalist Matheson and Criminalist Yamauchi.
Mr. Matheson, is he who you referred to previously as presently the chief forensic chemist?
Yes.
Okay. And was there also an evidence number, item number 19, that you recovered?
Yes.
When was that recovered?
That was recovered on June the 14th.
Where did you recover it from?
I removed item 19, which is hairs and fibers, from the glove in item number 9.
Did you package them up in some way?
Yes, I did.
In where?
I placed them in a, to the best of my recollection, a paper bindle, and put them in a coin envelope and assigned them item number 19 in their own envelope.
Yeah. Your Honor, at this time, I'd like to mark another exhibit. It would be People's 177 for identification.
177?
And it's actually a series of 5 boards called LAPD Evidence Disposition Summary. Perhaps we could wait for just one moment before we put them up to see whether. Okay, we can put up one with number 6 at the top first. Mr. Funk, perhaps you could step down for a moment and take a look at this. We've put up a board that's been, Your Honor, maybe we should mark this with the court's permission, 177A.
177A? The whole board?
Yes.
Okay.
Mr. Fung, have you seen this board before?
Yes, I have.
And did you have the opportunity to carefully examine this board and a series of other boards just like this one?
Yes.
All right. Now, did you have an opportunity to look at the photographs in the various cells next to the names Fung and Mazzola?
Yes.
And in several instances on the other board, were there cells that just had your name in it?
Yes.
Did you also look at the cells on all the other boards?
Yes, I did.
Now, was the resolution in the photographs good enough so that you could see what was depicted in the photograph?
Yes.
All right. With respect to, let's just start with 6. I don't think we have to go through all of them. But with respect to 6, what is shown in photograph in the cell LAPD collected LAPD and 6 next to Fung and Mazzola.
Up in the upper right-hand corner is the DR number. Here is the item number, and here is my initials.
What is number 6, the item depicted in the photographs?
So I'm going to refer to my notes.
Well, I mean, just, is it a coin envelope?
Yes,
or-
it is.
Okay. And is that the kind of coin envelope that is that the coin envelope that would have been used at one of the scenes?
Yes.
Do you have to refer to your notes to tell us which scene it was?
That scene, no, I do not need to.
Okay, which is that?
That is from the Rockingham scene.
Okay, do you need to refer to your notes to tell us where at the Rockingham scene this was collected from?
Yes.
Okay, can you tell us?
That was, item number 6 was recovered from the driveway close to the Rockingham entrance.
Okay, so if you can recall back to when we were showing the first Rockingham board that we discussed yesterday, there was an item number 6. Do you
Yes.
recall that? Would this be the envelope into which you placed that item number? Item
Yes.
number 6. Right. Now, was the date that you did it June the 13th of '94?
Date I collected?
Yes.
Yes.
Right. Now, when you went through this board previous to your testimony, did you check the dates and the photograph number using your crime scene identification list, just as you did a few moments ago with number 6?
That and my property reports, yes.
Okay. And was this an accurate summary of that information?
Yes.
And the crime scene identification checklist, is that a document that's made in the ordinary course of the crime laboratory's business when you're collecting stains from a scene
Yes.
or other evidence?
Yes.
And the property reports, are those also standard business records that are used at Los Angeles Police Department?
Yes.
Now, when you went down this particular board, did you see the packaging into which you placed the items that were collected accurately portrayed in the pictures
Yes.
next to your name, or your name and Ms. Mazzola's name?
Yes.
And did the pictures accurately portray that packaging?
Yes.
Now, how did you recognize the packaging in each instance?
In the photographs, there's either my initials or criminalist Mazzola's initials or some other identifying characteristics such as a coroner's case number that would be unique to that item.
Did you also look for the DR numbers?
Yes.
Did you do the same thing for all the other boards in this series?
Yes.
Your Honor, I'd like to put up the other boards, but I just need to get the witness to authenticate them. So I'm not sure whether we need to physically drag them over here or not. Was the court planning on taking its recess fairly shortly?
3 o'clock.
Okay.
Need a moment to recycle your exhibits. Go ahead.
As People's 177B, I have a similar board, and this has items 25 through 44.
All right, 177B.
Sir, do you also recognize this exhibit?
Yes,
And this was one of the other boards that you took a look at?
yes,
Okay, and did you go through the same process that we just discussed in connection with 177A of verifying the photographs, the dates corresponding to each one of the cells
yes,
that you collected? And was the information contained on this board true and correct?
Objection to that question, only to his initials.
Yes.
Only to
Rephrase-
what?
Rephrase.
Okay,
The information is accurate as to his participation, yes.
well,
Rephrase the question.
okay, let me ask it more specifically. Did the photograph accurately depict the packaging of the items, the various items that you collected or that Andrea Mazzola collected in your presence?
yes,
And did the dates accurately reflect when those items were collected?
yes.
All right. Now, let's take a look at 177C. This says 45 through 87. I'm sorry, 57. Is this another board that you looked at, Mr. Fung?
Yes, it is.
And did you go through the same procedure that you described with respect to 177A of verifying this board?
Yes,
And did the photographs in the cells under collected LAPD next to your name and/or Andrea Mazzola's name accurately reflect the packaging into which the items were placed that either you collected or were collected in your presence?
yes,
And were the dates also accurate?
yes.
Now, 177D. This contains item 59 through 82. Okay, now looking at this particular board, when you go down the LAPD collected column, every name here is someone else. Is that correct?
Yes.
So you did not participate in the collection of these items?
Yes, that's correct.
All right. Now let's see 177E. Sir, did you go through the same procedure with this board that you went through with 177A?
Yes.
And on this board, there are only 3 items that you collected?
Yes.
And those are which item numbers?
115, 116, and 117.
And did you look at the photographs to determine whether they accurately reflect the packaging that you placed those respective items in?
Yes.
And does the date accurately reflect when you did that?
Yes.
Okay, thank you. For the record, Your Honor, this was 84 through 305. Did you have occasion to go out to the location at Bundy since July the 3rd?
Yes.
And when was that you went out?
I've gone out there 3 additional times.
Did you go out there in February of this year?
Yes, I did.
For what purpose?
I went out there to take additional measurements with Special Agent Bodziak.
Yes.
Was he with the FBI?
Yes.
Do you know which division?
He's with, no, I don't know what the name of his exact division is.
But is it a scientific evidence type division?
Yes.
All right. Now, what materials did you bring with you out to the scene, if any?
We had some photographs and measuring devices.
Okay. Did you did you have photographs there that depicted the shoe prints as they existed on June the 13th?
Yes.
All right. And did you have occasion to go out again on March 25th?
Yes.
And why were you going out then?
I was out there to take even more measurements with DA personnel.
Do you recall who from the DA's office was with you?
Miss Martinez.
The young lady behind me?
Yes.
All right. Your Honor, at this time, I'd like to mark what appears to be a set of notes as People's 178 for identification.
And you've looked at them carefully?
What? Yes.
Good.
Well, I think we're finished with the Elmo today anyway, Your Honor.
Good.
Counsel's already seen these, but I'm just going to authenticate them with the witness. May I approach? Sir, show me People's 178 for identification. Do you recognize that?
Yes, I do.
And what are those?
These are measurements taken of shoe prints at the Bundy scene.
Is that a compilation of various notes that you took on the 3 dates that you just mentioned?
Yes.
Now, Mr. Fung, with respect to investigating a crime scene, which we talked a lot about yesterday, is there any single right way or right formula for going about investigating a crime scene?
There are general guidelines that people follow. However, there's no single right way in any circumstance.
Is the way that you go about investigating a crime scene subject to different opinions of different forensic experts, criminalists?
Yes.
Okay. Could two forensic experts have different ideas about exactly what to do at a crime scene?
Yes.
And, sir, is there a recognized principle in criminalistics that in every crime scene that has ever been processed, it is always possible to use hindsight to criticize the work at a later date?
Sustained.
Sir, have you heard of is there any recognized understanding within the criminalistics field regarding whether or not it is possible to process a crime scene in a way that no one could ever criticize?
Ground.
Calls for speculation.
Sustained. Leading.
It's okay, Your Honor. I don't think I have any further questions. Thank you.
Good afternoon, ladies and gentlemen of the jury. Good afternoon, Mr. Fung. How are you, sir?
Good afternoon.
Mr. Fung, I thought we would start with discussing the role of the criminalist. Would you agree that it is the role of the criminalist to preserve the integrity of evidence?
That is one of the roles, yes.
And that would mean that it's your job to make sure that evidence is not contaminated.
In some respects, yes.
It is not compromised or altered.
I object to the word
Vague.
compromised.
Vague.
It is not altered by the people gathering it.
Well, I object to that because, again, it's vague.
Overruled.
In all cases?
Yes, when you get to a crime scene, you see evidence. You don't want it to be compromised in the gathering in terms of the way you originally found it. You want it to be in the same condition as much as you possibly can as you originally found it.
Compound.
Overruled.
Not in all cases. There may be some cases where it might be raining out and you would want to move the evidence to preserve it.
Right, to preserve it in the original condition as that you found it, right?
Well, it's vague.
Sustained.
But you said that sometimes it may be raining out, so you want to protect the evidence so that you can gather it in as close as possible its original condition. Isn't that what you just said?
Not exactly. You would want to preserve it to maintain its integrity and so that it would retain its value to an analysis.
Okay. And it's your job to make sure as much as possible that evidence is not corrupted.
Well, I object to the word corrupt.
Sustained.
Well, that evidence is not tampered with.
Yes.
And would you agree that it is the role of the criminalist to be careful?
Yes.
Well, I object to that. It's overbroad.
Overruled.
And that you should not be in a hurry when examining evidence at a crime scene?
Generally, yes.
And you would agree that recognition of new clues beyond what the detectives show you is important.
It can be, yes.
And you would agree that sometimes extremely important evidence is not obvious as soon as you arrive at the crime scene.
Yes.
Criminalist wants to go through a process of careful reconstruction upon arrival at the scene.
Object to the phrase reconstruction.
Sustained.
Have you heard the term crime scene reconstruction?
Yes.
And that has a formal meaning, does it not?
Yes.
And what do you know it to mean?
A reconstruction is using the physical evidence at the crime scene to come up with a scenario as to what happened at that crime scene.
And so when you get to a crime scene, as much as possible, a criminalist would want to look at all the evidence and begin the process of reconstruction in an effort to find relevant clues.
Well, I object to its compound.
Oh, well, do you understand the question?
Yes.
All right, you may answer.
Not in all cases.
Would you agree that it is a principle of crime scene contamination to first protect the scene?
Crime scene contamination?
Excuse me, crime scene investigation, to first protect the scene,
Yes.
all right? You don't want to trample or obliterate evidence.
If it can be avoided,
You don't want to contaminate the scene.
yes.
You would want to conduct a quick search for perishable evidence.
Yes.
And then you would want to retreat and approach the scene slowly and methodically.
Yes.
And you recognize I'm reading from,
Sustained.
fair enough?
Yes.
Would you agree that it is important for a criminalist not to make assumptions in approaching a scene?
Yes.
It's important not to take shortcuts.
Objection made to the shortcuts.
Sustained. Rephrase the question.
Be important not to rush to judgments.
I object that's argumentative.
Sustained.
Would you agree that it's important for a criminalist to be accurate?
Yes.
Accurate and complete in making notes.
In making relevant notes, yes.
Accurate about the number of items that you collect.
Yes.
About the nature of the items you collect.
What do you mean by nature?
Description of the nature of the items that you collect.
Yes.
Who collected them?
In the notes?
Yes.
Not in all cases, no.
Well, you were referring before to your crime scene checklist, correct?
Yes.
And in your crime scene checklist, there are boxes, are there not?
Yes, there are.
And as you go across the page in the crime scene checklist, the boxes refer to item collected, and then next to that is by, correct?
Yes.
And that's a box where you're supposed to fill out who collected the item.
The crime scene...
Is that true?
No.
I asked him about the box.
Wait, wait, he just said no. He's finished his answer. Proceed.
As a criminalist, you want to be accurate about where the item is collected.
Yes.
And you want to be accurate about how the item is collected. What method is used.
In the notes,
In the notes, or in terms of your own recollections. You want to be accurate as to how items are collected.
as long as they're collected in a standard procedure, I don't see the need for taking notes.
Well, aren't
On
there
it.
different ways to collect various items of evidence?
Yes, there are.
And don't you think it's important to make notes about exactly which one was used on what occasion?
If it was relevant,
And isn't it important, as you're processing a crime scene, to keep accurate notes about the order of collection?
I don't see where the order of collection would necessarily have to be documented, as long as you had a time frame from which you could say when they were.
Well, on your crime scene checklist, right next to the box that indicates by, there's another box that indicates time, is there not?
Yes, there is.
And the purpose of the box that indicates time is to have the criminalist write down when an item was collected.
In certain circumstances, yes.
And when you have a lot of different items, in order to minimize confusion, isn't it a good idea to write down the time of collection?
Not necessarily.
And in your judgment, when you have a lot of different items of evidence that you're processing, it's not a good idea to memorialize the order of collection?
Not unless it was going to be relevant at some later time.
Now, would you agree that it's important for a criminalist to create an accurate chain of custody?
Yes.
And could you tell us, please, what you mean by a chain of custody? What's your understanding of it?
The chain of custody is a record of when evidence leaves one person's custody and is given to another person's custody.
And the reason that it's important to keep accurate records about the chain of custody is, or one of the reasons, is to prevent samples from getting mixed up.
Well, that's not my understanding of why chain of custody is necessary.
You don't think that an accurate set of records about where an item went, and who received it next, is of assistance in preventing mix-ups?
That may be a secondary,
Is that a reason?
that is one of the
Okay.
reasons.
Another reason to have an accurate chain of custody is to guard against cross-contamination of samples.
That's not my understanding of chain of custody.
You don't think chain of custody has anything to do with cross-contamination of samples?
That's not my understanding of chain of custody.
All right, is this a good point?
One more question.
One more.
And would you agree that one of the important reasons to have an accurate chain of custody is to prevent anyone from tampering with evidence?
That is a reason, yes.
Thank you.
All right, ladies and gentlemen, we're going to take our afternoon break. This will be a 15-minute recess. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations. See you back in 15 minutes. Mr. Fung, 15 minutes. All right, let the record reflect we've been rejoined by all the members of our jury panel. Mr. Fung is presently on the witness stand undergoing cross-examination by Mr. Scheck. Good afternoon again, Mr. Fung. You're reminded you're still under oath, sir. And Mr. Scheck, you may continue with your cross-examination.
Mr. Fung, you mentioned just before we broke that when you're filling out your item description form, you only will fill in the time of collection when you think it's relevant. Is that what you said?
Yes.
Now, is there anything in particular that would make you realize at the moment that you're collecting the item that later on down the line, the time of the collection was going to be relevant?
It is my general practice, my personal general practice, to write down the time when it is outside the time frame of my actual collection. If I, for instance, went to a crime scene at 8 o'clock and left at 12, if there was additional evidence which somehow was given to me by a detective or something like that, I would then write down the time frame.
Well, why don't we look at one of these forms? Your Honor, I'd like to mark the original, but let me establish this. The notes that you make, the original notes that you make on your field checklists, what happens to them?
In this case or in general?
In general.
In general, they're filed away in a file cabinet that stores these documents.
There's a rule at the Scientific Investigation Division that when you make out original notes, the original notes are to be stored in a particular place and preserved.
I don't know if it's a rule, but that's what happens.
Well, in the Field Procedures Manual, you're not familiar with any regulation that says that all original notes are to be preserved at the laboratory so others can look at them and get access?
I object because it assumes the fact not enough evidence.
Sustained.
Are you
Foundation.
familiar?
Foundation.
Are you familiar with a Field Procedures Manual?
I know that one has been written, but it has not been put in effect.
Well, isn't there a Field Procedures Manual that is in the truck that you go to crime scenes with?
I'm not aware of a procedures manual in the truck, no.
Are you saying, sir, that, are you aware of the existence of a document of 11 volumes entitled The Crime Scene Field Unit Protocol and Procedures Manual?
I have not been given that copy, no.
You've never seen such a document?
No.
And you have no knowledge as to whether or not such a document, such a manual, is actually required to be kept in your criminalistic truck for reference?
That's correct.
Well, moving back to your evidence collection sheets. There is an original set of documents, is that correct?
Yes.
All right. And you've reviewed the original set of documents in this case, have you not?
Yes, I have.
Now, there's an original page that refers to the items that you collected at Bundy.
Could you,
Your Honor, I'd like this to be marked offense next in order. What? 1069.
1069. About marking an exhibit?
Well, the original.
All right. With the court order. All right, what was the next in order? 1069.
Your Honor, may I put page 1 of the two-page document 1069 on the Elmo?
Yes.
Maybe we could just, maybe it would be clearer if we go close on just top of the page. Okay. Now, Mr. Fung, this document that we have up in the Elmo is the original of the evidence collection report that you filled out for the items seized at Bundy. Is that correct?
it's a portion of it, yes.
All right. And calling your attention to the, just even the first item that refers to the set of keys. Is that correct?
Yes.
All right. Now, next to that, there's a box that we're referring to with the word buy in it, correct?
Yes,
All right. And that was not filled out contemporaneously, was it?
that's correct.
It wasn't filled out at the time that it was collected.
That's right.
And then as you go down the page and you talk about the next item, the pager, that wasn't filled out either, was it?
Yes,
And as you go down the page, there was no notation whatsoever as to who collected which item.
that's correct.
All right. Now, I'd like to have this document marked as defendant's next in order. That would be 1070. Now, on this item is a copy of the evidence collection sheet from Bundy that you filled out with some additions before you came to court.
Yes.
And what you did is you reconstructed who collected what.
I mean, reconstructed.
You filled in the box that has by,
Yes.
all right? And when did you do that?
That was sometime after the crime scene had been done.
How many months?
Maybe 2 or 3.
And did you do this, was this your decision?
It had become an issue, and we decided to fill that in as best we could.
Who's the we?
You can answer the question.
In my mind, Criminalist Mazzola and I were working as a team, and it was not relevant who did what specifically. We were working so close together, it didn't matter.
My question, sir, is wouldn't you have greater confidence in your recollection of who collected which item if the form had been filled out at the time of collection?
Yes.
Now, you testified on direct examination that as to one of these items at Bundy, number, 52, that you were not present when that was collected.
That's correct.
And you testified, did you not, in August of this year at a proceeding? Do you remember that?
Oh, yes.
And were you asked these questions and did you give these answers? I'm now at page 531, Mr. Goldberg.
I think you misspoke yourself. August of this year, August of last year.
Did I say August of this year? It's getting difficult, Josh. It is August of last year.
Let's just not make it true.
Sorry, counsel.
All right. Starting at page 531.
Which hearing? The Griffin hearing?
Yeah. Question. Mr. Fung, you were the criminalist who collected the alleged drops of blood found at the Bundy crime scene, is that correct? Answer. I was one of 2 criminalists who was there collecting evidence, yes. Question. Okay. And did you personally collect the stains that have been given the item numbers 47, 48, 49, 50, and 52? Answer. I was present during the collection of them and assisted in the collection of those stains. Yes. We asked those questions. Did you give those answers?
Yes, I did.
And in that answer, you included item number 52.
Yes, I did.
And then at page 536 of that same proceeding, you were asked these questions and gave these answers. Question, Mr. Fung, you mentioned that you were collecting the blood specimens with a colleague named Miss Mazzola. Answer, yes. And with respect to the enumerated specimens, numbers 47 through 52, I believe you said that she did the collection and you observed her and, if need be, assisted her. Answer, to the best of my recollection, yes. You asked those questions. Did you give those answers?
Yes, I did.
And in the same proceeding again, at page 538, question, For each and every specimen that I just gave you as key numbers there, did you personally observe her collect them there, or were there 3 times where you were off collecting, or were there times that you were off collecting some specimens and she was collecting things at some distance from you? Answer, there were times that when I wasn't watching her all the time, no. Question, and so she would be collecting some of these withdrawn. As you sit here today, do you have a vivid memory as to which of the 60 or so items that you collected at Bundy she collected in your presence as opposed to those which were collected outside your presence? Answer, I do remember that the blood stains leading from where the victims were along the escape route, as it has been referred to in the past, I was there with her, personally supervising her. Question, for each and every one of those, answer, I believe so, yes. We asked those questions, did you give those answers?
May I have one
I-
moment just to look at the transcript for you? I just asked that you read down through line 10 of the transcripts that may be complete. On page 539, Counsel.
I don't think it's necessary, but I will for his benefit. Question, were there other bloodstains, however, that she collected at that scene which you personally did not supervise? Answer, yes. And as you sit here today, do you know which ones those were? Answer, not specifically, no. Okay?
Yes.
So in other words, at this hearing, you took great pains to indicate that you saw every one of those blood drops at Bundy, 47, 48, 49, 50, and 52. That you personally observed Mr. Mazzola swatch all of those, right?
Wait a minute, I object to mistakes in the testimony.
Sustained.
Did you take great pains to testify that you observed Ms. Mazzola collect all those blood drops, including 52?
Yes.
And your testimony today here is that you did not see her collect 52.
The collection process involves many steps. It includes the documentation also and the identification. And in that respect, I was present during those phases of the collection process.
You were asked on direct examination, did you see her collect 52? You said no, right?
Yes.
All right. In this prior proceeding, 3 times you were asked whether you saw her collect 52, and 3 times you said you saw it.
Could you repeat the question?
3 times you were asked if you saw Ms. Mazzola collect sample 52.
Well, I object that mistakes in the evidence.
Sustained.
Were you asked at that split hearing on 3 different occasions if you observed her and whether she did the collection of item 52?
Your Honor, I object that mistakes in the evidence.
Sustained. Why don't you break it down to each individual question?
All right. Were you asked on 3 different occasions, just the same questions I just read to you before, whether or not you observed Ms. Mazzola collect the blood drops 47 through 52? You were asked that.
I object that still mistakes the evidence.
Call roll.
If I could see the transcript, because I don't memorize everything.
Please tab the pages, take a look at it. Take your time.
Yeah.
Would it be fair to say, after refreshing your recollection from this testimony, that you previously testified that you observed Ms. Mazzola collect item 52?
Well, that's, to the best of my recollection at that time, yes.
All right? And at that time, you were testifying that you saw her collect each of those 5 blood drops at Bundy, 47 through 52.
Yes.
And now, you have talked it over with Ms. Mazzola. Is that right?
Yes.
Talked it over with anybody else?
To some extent, with Mr. Goldberg.
And after those discussions, you've now decided that you didn't observe her do that collection on item 52.
Your Honor, I'll check with Ms. Fagg as to the word collect.
Overruled.
In the actual manipulation of the swatch and blood stain, that's correct.
Let's get back for a second to the role of the criminalist. Now, would you agree that it is the role of a criminalist to be an independent, unbiased forensic scientist?
Yes.
And you should not harbor a bias as to the result of an investigation one way or the other.
That's correct.
And actually, are you familiar with a gentleman named Barry Fisher?
Yes, I am.
And who is he?
He is the lab director of the Los Angeles Sheriff's Criminalistics Laboratory.
And are you familiar with his book on techniques of crime scene investigations?
I have seen it and referred to it on certain occasions.
Have you considered it in forming your opinions about the role of the criminalist in crime scene investigations?
Your Honor, I'll check with Ms. Fagg as to the edition number.
Sustained.
5th edition.
I have not seen the 5th edition, no.
Well, would you agree that criminalists owe a duty to the truth,
Yes.
and that the sole obligation of a forensic practitioner is to serve the aims of justice?
Yes.
And what is important is that a forensic scientist conduct the investigation in a thorough, competent fashion and submit findings and reports and through testimony in a factual and unbiased manner.
Yes.
And would you agree that in your role as a criminalist, if you saw detectives using unsound procedures at a crime scene in gathering evidence, you would object?
Fagg as to the truth sound.
Overruled.
Could you be a little more specific?
If you saw detectives using procedures which you felt would impair the integrity of evidence as they were collecting it, would you object?
Yes.
If you saw members of the coroner's office taking steps in the collection of evidence at a crime scene which you thought would impair the integrity of the evidence, would you object?
I would tell the officer in charge of the scene I'd give him my opinion, yes.
And in testifying as to the facts of any particular case, would you agree that you should not just go along with the questions that are asked, for example, by a prosecutor in terms of the facts, you should independently recollect them from your own knowledge when you testify.
Sustain.
Well, would you agree that it's important that a criminalist not leave out important facts from a recitation of what occurred because you thought it would harm the prosecution's case?
Yes.
And it would be inappropriate for a criminalist to ignore misconduct by any law enforcement official.
Sustain.
Now, you testified yesterday. You were asked by Mr. Goldberg, is Andrea Mazzola a trainee? And you answered, no, she's a criminalist. Remember that?
Yes.
Now, when you testified previously in August of this year, didn't you tell us that Andrea Mazzola on June 13th was still in training?
I don't remember my exact words.
Did you tell us that she was a student and you were her teacher?
Your Honor, calls for a page and transcript citation.
Yes.
All right. Just to make sure, Mr. Goldberg, we'll start with 536 and we'll go into 537. We asked these series of questions, and did you give these answers? Question.
Certainly.
Starting on line 14. Ready?
He'll tell us when he's ready.
I'm sorry?
He'll tell us when he's ready.
Okay. Sorry.
Proceed.
Question. With respect to the enumerated specimens, numbers 47 through 52, I believe you said that she, Ms. Mazzola, did the collection and you observed her and, if need be, assisted her. Answer, to the best of my recollection, yes. Question. Okay, now is that the normal procedure, by the way, in cases where one criminalist does or another criminal acts as an observer? Answer, no. Question, why was that done here, sir? Answer, it was just the luck of the draw in this case. Miss Mazzola was the on-call criminalist, the homicide on-call criminalist, and I was also assigned to be her training officer that weekend. Now, you said you were her training officer that weekend. Is that because Miss Mazzola is pretty new to all of this? Answer, she's still a criminalist one, yes. Question, so during the period that she went out there to collect the specimens on June 13th, she was still in training? Answer, yes. Question, and you were there in a sense as a supervisor or teacher, is that right? Answer, yes. Were you asked those questions? Did you give those answers?
Yes, I did.
Now, Mr. Fung, Ms. Mazzola on June 13th was doing collections at her third crime scene.
I'll check, no foundation.
Sustain.
Do you know how many crime scenes Andrea Mazzola had collected evidence at before she collected evidence in this case?
I don't recall the exact number, but it was around 4 or 5.
4 or 5?
To the best of my recollection.
In preparing for your testimony in this case, did you review the transcripts of your testimony and Ms. Mazzola's testimony at that hearing in August?
I only went over mine.
Did you discuss with Ms. Mazzola your upcoming testimony in this case?
Only things regarding the crime scenes, not testimony itself.
Did you discuss this issue of her being a trainee with anyone at the Scientific Investigation Unit?
Sustained.
Have you had any discussions of the issue of Ms. Mazzola being a trainee as it relates to this case?
Yes,
Overruled.
Now, you testified in the grand jury in this case, did you not, sir?
yes, I did.
And before you testified in the grand jury, did you have discussions with anybody about the fact that Andrea Mazzola, a person who had done, as far as you knew, only 5 crime scenes, you think? Is that right?
Around there, yes.
Could be less.
Yes,
Had collected evidence in this case before you testified in the grand jury?
I don't recall discussing that with anyone.
All right. Well, looking at the evidence collected in this case, is it true that Ms. Mazzola was the one who swatched item 47? That's the first blood drop at Bundy, right?
Yes,
She did 48,
yes,
49,
yes,
50.
yes,
52.
yes.
That's the one you're now telling us you weren't even there to observe her do the swatching.
I don't recall being there, no.
And those were critical items in this case.
Sustained.
Isn't it true that with the exception of 55 and 56, which were blood from the outline of footprints, that Miss Mazzola was the one who swatched every blood stain at Bundy?
This states the evidence.
I'm asking him.
Footprints.
Overruled.
That's not entirely true, no.
You did 50, you swatched 55?
'55 was, yes, I did.
You swatched 56?
Yes, I did.
You didn't swatch any other stain at Bundy, did you?
Yes, I did.
Which one did you swatch?
I don't recall exactly which ones I assisted her with, but there were portions of stains where I actually took the tweezers and did the manipulation myself.
All right. Other than 55 and 56, Ms. Mazzola participated, actually swatched every other stain at Bundy?
To the best of my recollection, yes.
Rockingham. She swatched the red stain on the handle of the Bronco.
Under my direct supervision, yes.
She swatched stain 4,
Yes,
5,
yes,
6,
yes,
7,
yes,
8.
yes,
She did all of them.
yes,
Now, the Bundy glove found at Bundy.
yes,
Andrea Mazzola was the one that picked that up, put it in the brown paper bag.
the glove at Bundy.
Yes.
Yes,
The watch cap at Bundy. Andrea Mazzola was the person that picked that up and put it in the bag.
yes,
And incidentally, before you testified in this case, you reviewed videotapes, didn't you?
for this case,
Yes.
yes,
There were a whole two sets of videotapes you reviewed with the prosecution,
yes,
and these were videotapes from the media of you and Ms. Mazzola, and part of it was you and Ms. Mazzola at the Bundy scene.
Yes.
Now, incidentally, did you see any other videotapes besides the compilation of 2 cassettes that were provided by the defense to the court?
Videotapes concerning,
Of anything concerning this case? Any collections during this case?
I haven't seen any other compilations, no,
Any other videotapes at all?
on television.
Nothing that's been provided to you by anybody at the laboratory?
I can't remember any.
Have the district attorney shown you any other videotapes in connection with this case?
Yes.
His answer is yes.
And what were those?
There was a tape made by a company called Decision Quest.
And what was that tape of?
That was a tape of the Bundy location.
And were you present when that was made?
No.
Well, let's talk about your testimony at the grand jury. Mr. Goldberg, I'm now at testimony of June 22nd, 1994, at page 379, line 8. Do you recall being asked questions about the blood drops at Bundy and who swatched them?
At Bundy? Yes.
All right? Were you asked these questions and did you give these answers? Question: were there blood drops next to those shoe prints? Answer: yes, there were. Question: did you attempt to retrieve and preserve the blood found in those blood drops? Answer: yes, I did. Question: what did you do? Answer: I transferred the blood drops onto cloth squares or cloth swatches. What I did was wet the cloth swatches with distilled water and then applied them to the stain, the red stains, which were later determined to be blood, and they were transferred on in that method. Were you asked those questions? Did you give those answers?
Yes, I did.
And that wasn't accurate testimony, was it?
It was accurate in the sense that I did perform some of those functions on, but I don't recall exactly which ones I did them on.
Mr. Fung, didn't you just tell us that Andrea Mazzola was the one that swatched the blood drops 47, 48, 49, 50, and 52?
She was there and did partake in those, yes.
She was the one that did the swatching, the distilled water on the swatch, right? I think you
Have you
did.
finished your answer?
No, well, I need to explain more. During the collection of that trail, I also participated in the direct collection of the bloodstains, meaning I took hold of the tweezers and swatched some of those stains.
Did you tell the grand jury that Andrea Mazzola, a person who was in training, swatched those blood drops 47, 48, 49, 50, and 52? Did you tell them that?
I'd ask for transcript and page.
No, the question is, did he tell the grand jury that? Yes or no?
I don't recall that I did tell them that.
I mean, you didn't tell them that, right?
That's argumentative.
Did you or did you not tell the grand jury that Andrea Mazzola participated in swatching those blood drops at Bundy?
No,
The answer is no, you didn't tell them, right?
that's correct.
Okay. Let's talk about the blood drops at Rockingham and the stain on the Bronco, okay? Mr. Goldberg, I'm at grand jury testimony at page 390, starting at line 6. Question: how did you recover them? Answer: I recovered in the same manner described before, where I would wet a cloth swatch or several cloth swatches, if needed, apply it to the red stain, and then let the red stain transfer onto the cloth swatch. Where you asked those questions, did you give those answers?
Yes.
So you didn't tell the grand jury that Andrea Mazzola was actually the one that swatched that red stain off the handle of the Bronco, right?
At the time,
Did you tell them that?
no.
You said you did it.
Yes.
And you said the same thing about stain 4,
Yes.
5,
Yes.
6.
I don't recall, but yes.
In other words, you testified that you did all the swatching at Rockingham when in fact it was Andrea Mazzola, right?
No, I testified that I did the collection.
No. Did you not testify that you recovered them in the same manner you described before, where I would wet a cloth swatch or several cloth swatches if needed, apply it to the red stain, and then let the stain transfer onto the cloth swatch, right? You said that.
Yes.
You were telling the grand jury that you did it.
Yes.
Now, with respect to the Bundy glove, Andrea Mazzola was the one that picked up that Bundy glove.
Yes.
Mr. Harris. Your Honor, at this point, we'd like to play a videotape. Maybe I'll lay this foundation for it. You've seen a videotape, have you not, Mr. Fung, of Andrea Mazzola picking up the glove at Bundy and the watch cap?
Yes.
You saw that before you testified here.
Yes.
When you testified at the grand jury, you were testifying on June 22nd.
Yes.
That was just 9 days after this happened.
Yes.
Can we show the tape? Well, while he's searching for the tape, let me move on and let's discuss your testimony about the Bundy glove at the grand jury.
Perhaps I don't know where exactly they're going to put it.
Please.
So I need to see it.
All right. Ms. Fitzpatrick, can we just see it on council's monitors? I'm sorry? Is there audio on this, Mr. Harris?
No, sir.
All right.
You need to turn these on at the top.
Mr. Goldberg?
Okay.
All right.
stop that for a second, please? Right, now, Howard, can you stop that? No, we can't stop. What we've seen so far, that's Andrea Mazzola, is it not?
Yes, it is.
And she is picking up first the Bundy glove, is that correct? You want to see that again from the beginning?
Yes.
Okay, let's start from the beginning. I'm sorry. Is that the beginning, Howard? Okay, I'm sorry, that's the hat, is that correct?
Yes.
And she's putting it in a bag, is that correct?
Yes.
All right. That's a car passing in front. Now, do you recall, Mr. Fung, if you were anywhere around observing her doing this?
I don't specifically recall it, no. That's her picking up the bag, folding it, putting the evidence tag by a tree, I guess. Is that correct? I don't know if it was by a tree.
By the edge of the steps.
It appears so.
And now she's picking up the glove.
Yes.
And between, you can finish. Picking up the knit hat and picking up the glove, she did not change her gloves.
I don't know if she did or not.
Oh, did you see that in your observation? This is not the first time you've observed this tape, is it?
No.
You've looked at it a few times, haven't you? That's okay. You can take it. Let's get rid of this. Okay. Now, when you testified in front of the grand jury 9 days after that occurred, were you asked these questions and did you give these answers?
Can I leave it?
Page 377 to 378, starting at line 8. Question: was one of these items a brown man's leather glove? Answer: yes, it was. Question: directing your attention to the set of photographs, People's 26, and you recall that when you testified in the grand jury was photographs of the Bundy glove, correct?
I don't recall, but
You recall being shown that in the grand jury, photographs of the Bundy glove?
I recall photographs, but I don't remember what
All right.
number it was.
You don't remember it was 26, but you recall during your testimony that Ms. Clark pointed to pictures of the Bundy glove?
Yes.
Okay. Can you tell us if you see the glove you have just referred to? Answer: if I may take a closer look. Yes. Answer: yes. The glove I'm referring to is shown there in photograph A. The person is pointing to it there. It's also in photograph B in the bottom of the left-hand corner. It's in photograph C next to the photo ID. Question: in photographs A, B, and C, do they actually depict the glove in the location and condition you found it? Yes. Question: what did you do with respect to that glove? Answer: initially, I measured to see, to locate where it was, found, documented that location, and then placed it in a paper bag for later processing. We asked those questions. Did you give those answers?
Yes.
And that testimony wasn't accurate, was it?
That I personally did all that stuff? No.
Right. You did not tell the grand jury that Andrea Mazzola was the one that picked up the hat and picked up the glove, right?
That's correct.
Now, you did not tell the grand jury when you were describing collecting this evidence about the existence of Andrea Mazzola at all, did you?
Well, it's irrelevant unless he was asked who else was there.
Sustain.
Well, you were asked a whole series of questions in the grand jury about how evidence was collected.
Yes.
And you were asked specifically about items that you considered at that time important to this case.
Well,
Sustain. It's irrelevant. What he thought was important at that time.
Well,
But I think you've already established that what the testimony was, counsel.
okay. And that testimony you gave the grand jury was under oath.
Yes.
Now, did you decide on your own not to mention to the grand jury that Andrea Mazzola was involved in collecting the evidence in this case?
I don't think it was a conscious decision one way or the other. It's just I gave the answers as they were asked to me.
And left her out?
Yes.
And you didn't have any discussions with anyone at the laboratory, SID, before you testified? Or did you have any discussions with anybody at the laboratory before you testified?
Concerning what?
Concerning your testimony.
Before the grand jury?
Yes.
I don't recall
You
having...
talked with, who's Michelle Kessler?
Michelle Kessler is the chief forensic chemist. She's the lab director of our laboratory.
Did you discuss your testimony with Michelle Kessler before you went before the grand jury?
I don't recall discussing it with her.
Did you discuss your testimony with Greg Matheson?
I don't believe so.
He, at that time, was the head of serology.
Yes.
Did you discuss your testimony in the grand jury with Ms. Clark?
I don't believe so.
Before you testified in the grand jury, you did not discuss your testimony with Ms. Clark?
I don't recall discussing it with her, no.
So I take it then that there was no discussion between, withdrawn. Did you have a discussion with anyone else in the district attorney's office before you testified at the grand jury?
I don't recall discussing the case with anybody, no.
So there were no discussions whatsoever before you testified in the grand jury in this case about your testimony with anyone from the district attorney's office?
I don't recall any.
So in other words, the failure to mention that Andrea Mazzola was involved in the collection of evidence in this case was something that you decided to do on your own.
Your Honor, I'll object because there's no evidence he was asked.
Well,
It wasn't a conscious decision. That's just the way I answered the questions.
Did you answer those questions in that way, leaving Andrea Mazzola out, because you were worried about the fact that a trainee had been involved in collecting important items of evidence in this case?
No.
Not just involved, but she had a major role, didn't she?
Yes, she did.
Not only did she collect the bloodstains that we've talked about and the glove and the hat, but she also did crime scene diagrams
Yes.
of Rockingham
Yes.
and Bundy.
Yes.
Now, you subsequently testified at a preliminary hearing in this case, did you not?
Yes, I did.
And at the preliminary hearing, were you asked these questions, and did you give these answers? And out of completeness, I'm starting at testimony of July 7th at page 39, line 17. Tell me when you're ready, Mr. Goldberg.
Scheck,
Can I?
proceed.
Question. How do you collect blood stains from a crime scene? Answer. Generally, stains are transferred onto a swatch by first wetting the swatch with distilled water, applying it to the stain so the blood is absorbed onto the swatch, and at that point it's put into a plastic bag and then put into a coin envelope where it is labeled with the corresponding photo ID number. Question. Is it also your job, sir, to package all of the evidence that you collect and label it with what is known as a DR number? Answer. Yes, it is. Question. And did you do so in this case? Answer. Yes, I did. Now I'm going to direct your attention to items number 1 through 8. Those are the Bundy, the stains at Rockingham, correct?
1 through 8, some of them were stains, yes.
Did you prepare a report documenting what items numbers 1 through 8 are in this case? Answer, yes, I did. Did you collect them, sir? I did, along with my assistant criminalist, Mazzola. Question, is that another criminalist with the Los Angeles Police Department? Answer, yes. Question, do you usually send 2 criminalists to a crime scene? Answer, not always, no. Question, what was this criminalist doing with you on that particular day? Answer, she was there to learn how to process crime scenes. Answer, you were showing her how it is done. Answer, yes. Were you asked those questions, and did you give those answers?
Yes.
All right. Now, when you said that Andrea Mazzola was there to learn how to process crime scenes, and you were showing her how it was done, you were intending to convey, were you not, that you did most of the work and she was observing it.
I don't know if that was my intention with that statement.
Well, this was a preliminary hearing that you knew on national television.
Yes.
And did you have any reluctance in testifying that it was Andrea Mazzola that swatched primarily, all right, you said you swatched 1 or 2 times the Bundy blood drops, is that right?
May have been more than that.
She did primarily all the Bundy blood drops, right?
She did a good portion of them, yes.
And she did the Rockingham blood stains exclusively.
Well, it's vague as to what do you mean swatching?
She swatched the Rockingham blood stains exclusively.
I wouldn't say exclusively.
Well, you didn't swatch the blood stains at Rockingham, did you?
There may have been times when I did take and show her techniques that I use.
Do you remember that now as you sit here?
I may have.
Well,
I don't,
did you or didn't you?
to the best of I don't recall specifically which ones, but I do recall having manipulated or not manipulated, but taken the tweezers and used them at Rockingham.
You do?
Yes. But she did the most
She
of the...
did most of it,
She
right?
did most of it, yes.
Right. But when you were testifying at the preliminary hearing, you were saying that you were showing her how it was done, and weren't you trying to convey the impression that you did it and she was thus just there as an observer?
I object because it misstates this testimony.
Sustain.
You were asked at the preliminary hearing, in these questions and answers that I read to you, do you usually send 2 criminalists to a crime scene? And your answer was not always no. You recall that?
Yes.
Now, wouldn't it be is it the policy of the LAPD Scientific Investigation Unit to send at least 2 criminalists to a double homicide such as this case?
I wouldn't, at that time?
Yeah.
At that time, there was no hard and fast rule to send 2 criminals to a double, no.
It's your testimony that on June 13th, as far as you were concerned, it would not be the policy of the Scientific Investigations Unit of the LAPD to send 2 criminalists to a double homicide?
That's not the policy at that time, no.
Sorry? Well, you're aware, I just have a few minutes for the break. You're aware that there is a policy about notifying supervisors in certain cases,
Yes,
all right? And is this in that manual, do you know, the manual that you are not so sure you're familiar with?
I have not reviewed that manual that you're referring to.
Well, how do
if
you
it
know about this
exists.
policy?
This is a policy that was given to the criminalists verbally.
Okay, so
Of
you
the
got this
laboratory.
verbally, you've never seen a piece of paper about this policy?
Well, what policy are you referring to?
Well, do you know of a policy that says that supervisors must be notified immediately when a case, number 1, involves an individual or a group of notoriety?
Yes,
And that the second factor in this policy is that there might be a significant number of press at the scene.
Your Honor, this line of questioning is irrelevant.
that is one of the factors in determining whether to call a supervisor, yes.
Right. And the reason that press is important, would you not agree, is that when the press get to a scene, that makes it difficult sometimes for criminals to collect evidence.
Not generally, no.
Well, if the press arrives at a scene, sometimes that draws a crowd.
Yes,
It may be difficult to keep people away from the crime scene, getting into it.
it's a possibility.
And the policy about immediate notification of supervisors includes any case that might be considered unusual
Yes,
and involves 2 or more than 2 murders, correct? More than 2 victims.
yes,
Right, so out of the 4 factors, wouldn't you agree that this case certainly fit in to at least 3?
of notifying a supervisor?
Yes.
Yes,
And the reason cases are picked out to notify supervisors is that these are the kinds of cases that would involve additional support and extra attention.
possibly.
And you knew right away that this was that kind of case, right?
I knew this was going to be a high-profile case.
And when you testified in the grand jury, you knew that this kind of case, from the moment you got it on June 13th, would be that kind of case.
A high-profile case?
Well, high profile, one that would involve press, one that was unusual.
I don't know if it's unusual, but it is high-profile.
One that would involve immediate notification of supervisors,
Yes,
one that would likely call for at least 2 criminalists.
I can't determine what a supervisor would say in that
All right.
instant.
I guess this is an appropriate place to stop.
All right. All right, ladies and gentlemen, we're going to take our recess as far as the jury is concerned now until tomorrow morning. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't fight over the TV. Don't allow anybody to communicate with you with regard to the case. Don't conduct any deliberations till the matter has been submitted to you. Be kind to each other. All right? I'll see you back tomorrow morning, 9 o'clock. All right, Mr. Fung, you may step down. You're ordered to return at 9 o'clock.